Good morning, everybody. Hope everybody's doing well today. Still don't see Member Duval, but I think it's 9:05, so I think why don't we just get started? And welcome everybody to our monthly meeting here today, June 25th, 2021. And I'd love to start with the roll call this morning to start us off. And Ms. Jones, would you mind doing that for us?
Happy to do that. Good morning. We'll begin with the roll call. Member Bitzer, are you present?
I am here.
Member Cates?
Here.
Member Duval? Give him a few more minutes. Member Garcia?
Here.
Member Honker?
I am here.
Member Trujillo Davis?
Here.
Chair Sweeney?
Here. Thank you so much for that, Ms. Jones. Appreciate that. All right. Looks like we have a quorum this morning. And hopefully Member Duval is able to jump on in a few minutes. Why don't we go to the next agenda item, number 2, which is the approval of the agenda.
I'll move approval of the agenda.
Thank you, Member Bitzer.
I'll second.
Thank you so much for that second. And any discussion regarding any changes? I just want to check. I'm looking at our members. No discussion. All right. Ms. Jones, would you mind doing roll call on the vote on the approval of our agenda for June 25th, 2021?
Yes. Would you confirm with me who seconded that motion, please?
That
Yeah.
was me.
Mr. Honker, thank you. Okay. Here we go. Member Bitzer?
Yes.
Awesome. Member Cates?
Yes.
Member Duval still is not with us. Member Garcia?
Yes.
Member Honker?
Yes.
Thank you. Member Trujillo Davis?
I apologize. I got kicked off for a brief second. I don't know what we're voting on. I think it's the agenda.
The agenda, yes.
Oh, yes.
Okay. And Chair Sweeney.
Yes.
All right, the motion passes.
Thank you, Ms. Jones. Appreciate that. Next on our agenda, now that it's passed, is the approval of our May 28, 2021 minutes.
I move we approve the minutes from the May 28th, 2021 meeting.
Thank you, Member Honker. And Member Garcia seconds. Is there any discussion regarding that approval or the motion, I should say? Great. I hope everybody was able to review those. So if there's no discussion and no suggested revisions, Ms. Jones, would you mind going through roll call for the vote to approve our May 28, 2021 minutes?
Yes, Madam Chair. Member Bitzer, how do you vote?
Yes.
Member Cates?
Yes.
Member Duval, have you joined us? Member Garcia?
Yes.
Member Honker?
Yes.
Member Trujillo Davis?
Yes.
And Chair Sweeney?
Yes.
Thank you. The motion passes.
Thank you, Ms. Jones. Appreciate that. Next on our agenda is the reconsideration of virtual platform to be used for EIB 21-27 rule hearing. Our legal counsel, Carla, would you mind sharing any additional information on this?
Sure, Madam Chair. I will preface this with that Ms. Katz with the department was inadvertently left off the list of counsel for this matter. So obviously, to the extent she and other party counsel want to chime in, please feel free to do that. At the last meeting, it was agreed upon by the board that this hearing, which is scheduled to take place beginning September 20th, would take place via virtual platform. The board subsequently made a second motion, which was passed to designate Zoom as that platform. Since that time, there have been technological and administrative concerns raised with Zoom specifically as a platform to be used because the department and the board have been experiencing just technical difficulties with that platform. So this item is just to reconsider specifying Zoom as the preferred platform, and if the board would entertain it, leaving it open-ended as to which platform that hearing would take place on. And that's all I have to say on the matter. If perhaps Ms. Katz would like to also add additional context.
Thank you. Thank you, Carla. And Ms. Katz, please feel free to share any insight or discussion on this matter.
Thank you, Madam Chair and members of the board. Lara Katz on behalf of the New Mexico Environment Department. Council Soloria stated generally the issue, just that we would like to have it be open-ended as to which platform we choose, just and based on what the department's IT section determines would be the best for this particular hearing. And we don't think it's necessary for the board to specify the platform that we use. And so we would just ask that be reconsidered and simply left open for determination by the administrative folks which platform is used.
Thank you, Ms. Katz, for that input. And Ms. Soloria, I see a lot of other stakeholders here listed. At this point, should I open it up to anybody else's comments regarding this, or should we have a discussion first?
Yes, Madam Chair, I think it's appropriate if counsel for the other parties want to offer any additional comments. I don't know if everyone has a raise hand function. If you would like to speak, maybe that would be the best way to run through it. Pam, are they able to unmute themselves?
Yes.
Okay.
Yes.
Yeah, and for those others that are listed, that would be Ms. Tanis Fox, David Bake, I hope I said that right, Council for Conservation Voters of New Mexico, Danae Kerr, Earthworks, Natural Resources Defense Council, San Juan Citizens Alliance, Sierra Club, and 350 New Mexico, and Elizabeth Filon. I apologize if I don't say this pronunciation correctly. Paranjos, Council for Environmental Defense Fund, Eric Heiser, Brandon Curtis, let's see, I'm trying to go through this, and Delva Molenberg, as well for the New Mexico Oil and Gas. So for any of those that I just listed, and that is on our public agenda here, if you would either raise your hand, your camera, and raise your hand, I can see you, all right? And then we can entertain your comments. Ms. Fox, I see your hand raised. The floor is yours.
Thank you, Madam Chair, members of the EIB. I'm Tanis Fox with Western Environmental Law Center on behalf of the clients that the chair identified. I don't have a raised hand function in my Zoom for some reason, so I'm sorry I can't do that. I can only raise my hand. We concur in the suggestion that the department be given the flexibility to decide which platform would work best from a technical and administrative and logistical standpoint. And that's all I have to say.
Thank you, Ms. Fox. Appreciate your comments. And anybody else? I'm trying to look here. Again, if you don't have the raise hands function, maybe turn your camera on or unmute yourself. That would be helpful. All right. Well, if there's no other input from those listed, I look to our board members. Yes, Member Bitzer.
I move that we authorize the department to choose the meeting method, the cyber method of meeting.
Thank you, Member Bitzer.
I'll second.
Member Honker seconds. Thank you, Member Honker. Any further questions or discussions? Yes, Member
Just,
Honker.
just a question. So did we specify Zoom in our motions last time? So we need to override that with another decision here to make it the department's prerogative to choose the platform.
That is correct, Member Hunter.
Okay, just want to make sure.
Thank you. Yes, Member Davis.
I just had a question kind of about future items. Since the health order, I believe, is being lifted, or will we be going back to our in-person meetings here in the near future? Does anybody have any information on that?
Thank you for that question.
Member Trujillo Davis, for purposes of this hearing, because the notice had to go out early enough to meet notice requirements, the public will only be able to participate via the virtual platform because that's how we've noticed it. At the last meeting, there was discussion about possibly the members meeting in person, depending on the board's risk tolerance and all of that. But there would be technological considerations on that end as well, because you would have to enable the board members to meet physically and then broadcast it in a way to the public to have them participate equally in an equal fashion. So that's up for consideration and to be hammered out. I don't think we have a definite answer about how that's going to happen, at least for that September meeting. As far as other meetings, the board's regular July meeting, like I said, that ultimately will be up to the board, considering again the technological aspect of having the public participate at the expected level.
Thank you so much, Ms. Solaria. Yes, Member Honker.
Yes, I did notice that the department put out a notice on the September 20th hearing the other day. I took a quick look at that as we were discussing this. I didn't see a specific mention of Zoom in that. Would that have to be renoticed, or is it flexible under the notice that was issued the other day?
Thank you, Member Honker. Ms. Katz?
Thank you, Madam Chair and Member Honker. The department specifically left that open-ended in the public notice for the purpose of being able to request that the board do this and leave it open. So we're good with the public notice on that issue.
Thank you for that. Is there any other questions or discussion? If not, Ms. Jones, could you so kindly walk us through our roll call vote on this?
Certainly will. We'll begin with Member Bitzer,
Yes.
Member Cates.
Yes.
Has Member Duval joined us? I don't think so. Member Garcia,
Yes.
Member Honker,
Yes.
Member Trujillo Davis,
Yes.
and Chair Sweeney.
Yes.
The motion passes, Madam Chair.
Thank you so much. Appreciate that and everybody's input on that. Next item is the public hearing, EIB 21-07 in the matter of proposed amendments to 20.2 2.79 NMAC permits non-attainment areas petition for regulatory change. And so at this point of time, I believe it's the time for me to turn it over to Vice Chair, I think is the, yes, Amanda Trujillo Davis as the hearing officer.
I'll just check that our reporter is ready to go. She has indicated she is ready to go. Thank you.
Thank you.
So quick question here. I can't see on my Zoom when people raise their hand or anything like that. My screen isn't showing me that. Is that all right?
Can you see their faces, or is it that you don't see a raise hand function?
No, I see raise hand function. I just only see 4 people at a time, and I have to slide over to see the other people. So if somebody's raising their hand, I can't see them unless there's a different view.
Member Trujillo Davis, if you click on view, which is on the top right hand corner of the application, and switch to gallery view, you're usually able to see more thumbnails.
Member Trujillo Davis, are you on your phone or on your computer?
I am on an iPad.
Okay, yeah,
I wonder if that's why.
yeah, I believe so.
I can switch it over to my laptop. I was just keeping it open for all my documents that we have going today. So, yeah, I can switch it over real quick if you don't mind me taking a couple minutes to do that.
That would be fine. I think it'd be helpful.
Okay.
If you're only seeing 4 at a time here. So I think we have 30 participants right now.
Okay. I'm going to log off this one and I'm waiting to be led into the next one. Okay, can everybody hear me all right? Okay.
Yes.
Yeah. All right, well, fix that. Thank you. Okay, this hearing will come to order. Today is June 25th, 2021. The time is now 9:23 a.m. My name is Amanda Trujillo Davis. I have been designated by the board to serve as hearing officer, and I will be advised by the board's counsel from the Office of the Attorney General, Carla Solaria. May we have a roll call of the board?
Yes. Member Bitzer, are you present?
I am indeed.
Member Cates?
Yes, I am.
Member Duval? Member Garcia?
Here.
Member Honker?
Yes, I'm here.
Member Sweeney?
Here.
And Member Trujillo Davis.
Here.
You have a quorum.
Thank you, Ms. Jones. Okay. This is a hearing in EIB 21-07R to consider the proposed amendments to 20.2.79 NMAC permits non-attainment areas. Due to the COVID-19 pandemic or COVID-19 public health emergency declared by the governor, the following guidelines for public gatherings set out by the Department of Health. This hearing is being held online via Zoom platform. 20.1.1.306 NMAC does allow for participation via conference, telephone, or other similar device, given all participants are able to hear. If at any point during the hearing technical difficulties arise, please bring them to the attention and efforts will be made to remedy the situation. The petitioner in this matter is the New Mexico Environmental Department, Air Quality Bureau. Wild Earth Guardians filed a notice of appearance and is party to this proceedings, but did not file a notice of intent to present technical testimony. Wild Earth Guardians will not offer any technical or non-technical witnesses. There will be designated time for any member of the general public to present non-technical testimony. This hearing will be conducted in accordance with the Open Meetings Act and State Rules Act, the Environmental Improvement Act, the Air Quality Control Act, and with this board's rulemaking procedures. This hearing is being reported by Ms. Teresa Dubois from Albuquerque Court Reporting Services. Parties interested in obtaining a copy of the transcript may contact the court reporter directly at the conclusion of the hearing. Copies of the proposed amendments have been available on the department's website and at the department's office, as well as an interested party upon request. The hearing will be conducted in a fair, impartial manner to assure that the relevant facts are fully elicited and provided a reasonable opportunity for all persons to be heard without making or hearing unreasonably lengthy or burdening the record with unnecessary repetition. The rules of civil procedure and evidence shall not apply in this hearing. As hearing officer, I will make such orders as may be necessary to preserve decorum and to protect the orderly hearing process. To that end, I ask that all persons in this hearing be silent, please silence their cell phones. During the hearing, please be sure to mute yourself until you wish to speak to help minimize the background noise. All hearings shall proceed as follows. The board staff will present pre-filed exhibits. Exhibits admitted into evidence are available by review by the public. 2, all testimony will be taken under oath. 3, as hearing officer, I will rule on any objections to evidence and will admit any relevant evidence unless I determine the evidence is incompetent or unruly repetitious. Any persons offering an exhibit shall provide an original to the board administrator and copy to each of the board members and to its legal counsel, and shall also provide additional copies to persons attending the hearing. If visual aids are used, legible copies must be submitted for inclusion in the record. Please know that the board will not make copies of any exhibits used at this hearing. Any person who wishes to make a brief opening statement before presentation of his or her direct testimony may do so. The petitioner will present its direct testimony on the proposed amendments, and petitioner's witnesses will stand for cross-examination by Wild Earth Guardians, the board, and any other person in attendance. Wild Earth Guardians will have an opportunity to present an opening statement. If any other persons, including members of the public, wish to present non-technical testimony about the proposed amendments, they will testify as called upon. If you are a member of the public, please email the board's administrator at pamela.jones@state.nm.us to notify us that you intend to present non-technical testimony and include any exhibits being offered. Because this hearing is being transcribed, please remember that only one person may speak at any time. Please direct your testimony and answers and questions to the board members. Any person who testifies is subject to cross-examination on the subject matter of his or her testimony and on matters affecting his or her credibility. The petitioner has the option of presenting its witness as a panel for purposes of cross-examination. Cross-examination by the other party will be conducted at the conclusion of each presentation, followed by cross-examination by the board members and the hearing officer, followed by cross-examination by the public. Please remember to direct all testimony and answers to questions to the board itself, even if someone other than a board member has asked the witness a question. Any person attending the hearing is entitled to conduct whatever cross-examination is required for a full and true disclosure of matters at issue in the hearing. As hearing officer, I may limit cross-examination to avoid harassment, intimidation, needless expenditure of time, or undue repetition. At the petitioner's discretion, and if time permits, rebuttal testimony may be given at the conclusion of the public testimony in the same order as a direct testimony. Any person who wishes to make a brief closing argument may do so at the conclusion of the hearing and at the same order as a direct testimony. So moving on to evidence and testimony, we will now proceed. Does the board staff have any exhibits to introduce as evidence?
I do, Madam Hearing Officer. Exhibit 1, which is the petition to amend 20.2.79 NMAC. Exhibit 2, Wild Earth Guardians entry of appearance. Exhibit 3, NMED's notice of intent to present technical testimony with exhibits. And Exhibit 4, Wild Earth Guardians pre-hearing statement with exhibits. That's all.
Thank you, Ms. Jones. Okay. Are there any questions from the board members or objections? Exhibits 1 through 4. Oh, I'm sorry. Are there any questions or objections? Okay. I don't see anybody raising their hands or anything. So exhibits 1 through 4 are admitted into the record. If there are no other preliminary matters, we will move to testimony by the petitioner.
Good morning, Madam Chair, Madam Hearing Officer, members of the board. My name is Andrew Knight. I am Assistant General Counsel for the New Mexico Environment Department. With me today are Mr. Neil Butt, Dr. Kirby Olson, Mr. Michael Baca, and Mr. Kerwin Singleton from the department's Air Quality Bureau. And recently reviewing our permitting rule for non-attainment areas, the department determined that some minor corrections and updating of language was required to bring the rule more closely in conformance with federal regulations. And so we have filed the petition to amend the rule, and I would like to present our testimony to support those proposed amendments. Mr. Neil Butt will present the department's testimony. The other witnesses are here to answer questions as a panel. And they will not provide any direct testimony. And with that, I would like to have my, we may as well have all the witnesses sworn in by the court reporter, if that's all right.
I think that sounds reasonable. Ms. Dubois, do you have any objections to that?
No. Would you all please raise your right hand to be sworn in? Do you all swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
I do.
Thank you.
And with that, I would like to call my first witness. Having been sworn, Neil, could you state your full name for the record?
Yes, my name is Neil Butt, Nealbutt.
And where are you currently employed?
In the control strategy section of the New Mexico Environment Department's Air Quality Bureau.
And what do you do for the Air Quality Bureau?
I'm an environmental analyst. I develop air quality regulations and state implementation plans, or SIPs, to regulate air pollution emissions in New Mexico. I also research assigned air pollution topics, analyze data, prepare reports, and present summaries and conclusions to management.
How long have you held this position?
Since March of 2014.
Okay, and what did you do before taking this position with NMED?
I worked for the City of Albuquerque's Environmental Health Department for 17 years, the last 13 of which were as an environmental health scientist in the Air Quality Division. I served as the lead for promulgating air quality regulations and SIPs governing air quality inside Bernalillo County under the jurisdiction of the Albuquerque-Bernalillo County Air Quality Control Board.
What is your educational background?
I hold a Master of Science degree in biology from the University of North Dakota, a Bachelor of Science degree in biology, and a Bachelor of Arts degree in environmental planning and design from UNM, an Associate of Applied Science in Environmental Protection Technology, and an Associate of Applied Science in Criminal Justice from CNN.
Thank you. Did you provide written pre-filed technical testimony for inclusion in our notice of intent?
Yes, it was included as an MED Exhibit 2.
And do you have any changes or corrections that you would like to make to that testimony now?
No.
And do you therefore adopt that pre-filed written testimony as your testimony under oath here today?
Yes.
And let's see. Do you have a summary of your written testimony that you would like to present to the board?
Yes.
And Madam Hearing Officer, again, before we forget, I would like to move that the exhibits in our notice of intent be formally admitted into the record at this time, if there is no objection.
I believe we already did that. Is that correct, Ms. Soria?
Well, I know I guess the board or the board administrator moved admission of our notice of intent, but I just wanted to make sure that the individual exhibits that are within our notice of intent, I just wanted to make sure that those are part of the administrative record for this hearing, in case there's any ambiguity.
Plus the first amended Exhibit 11 too.
That's true. We, as Mr. Butt pointed out, we did supplement our Exhibit 11, and I just wanted to make sure that that is included in the record.
Could you identify for the record, Ms. Miller,
I'm sorry, Miss Solaria, we can't hear you.
Can you hear me now? Yes. I was asking Mr. Knight to just state for the record the exhibits he's moving to admit. So identify by number. You don't have to list them all, but exhibits 1 through, I believe it's 11. And then Member Trujillo Davis can ask if there are any objections.
Right. Thank you. Yes, I would like to formally move admission of the department's exhibits 1 through 11 as included in our notice of intent, and also our amended exhibit 11, which was filed later on.
I think we can go ahead and do that. Do we need to, do I just need to make a motion or do we need to vote?
No, so council has asked to move those into admission. You can ask if there are any objections, and hearing none or addressing same, you can admit them.
Okay. So are there any objections to admitting the identified documents into the record?
No objections.
Okay, let's go ahead and admit them then.
Thank you, Madam Hearing Officer. So, Mr. Budd, could you please summarize the reasons for the proposed amendments?
Thank you. Madam Hearing Officer, Madam Chair, members of the board, I'm here to present the New Mexico Environment Department Air Quality Bureau's proposed amendments to 20.2.79 NMAC permits and non-attainment areas, which I will refer to as Part 79. Attachment 2 of NMED Exhibit 1 shows the department's proposed amendments to Part 79 in red line strikeout format. The Air Quality Bureau of the New Mexico Environment Department proposes to amend Part 79 to make technical and administrative corrections to the rule in connection with the United States Environmental Protection Agency's designation of an area near Sunland Park, New Mexico as marginal non-attainment area for the 2015 National Ambient Air Quality Standard, or NAAQS, for ozone. Part 79 sets forth permitting requirements for new major stationary sources or major modifications of existing sources if those sources will be A, located within a non-attainment area designated pursuant to Section 107 of the Clean Air Act, and will emit a regulated pollutant for which it is major in which the area is designated non-attainment for. Or B, located within an area designated attainment or unclassifiable pursuant to Section 107 of the Clean Air Act, and will emit a regulated pollutant for which the source is major, and the ambient impact of such pollutant would exceed any of the significance levels identified in the table at subsection 20.2.79.119.A NMAC at any location that does not meet the NAAQS for the same pollutant. A source subject to Part 79 must submit a permit application to the department and cannot construct or operate the new source or modification until it receives a permit or a permit revision. On October 1st, 2015, the EPA revised the 8-hour ozone primary and secondary NAAQS downward from 0.075 parts per million to 0.070 parts per million to provide increased protection of public health and the environment. The primary standards are set to protect human health, while secondary standards are set to protect public welfare. Upon promulgation of a new or revised NAAQS, EPA is required to designate all areas of a state as either attainment, unclassifiable, attainment/unclassifiable, or non-attainment for the standard. Accordingly, the EPA designated the southeastern part of Doña Ana County, known as Sunland Park, as a marginal non-attainment area for the 2015 ozone NAAQS on August 3rd, 2018. In December of 2018, EPA promulgated the 2015 ozone NAAQS implementation rule, which specifies non-attainment area SIP requirements. This final rule, referred to as the 2015 ozone SIP requirements rule, is largely an update to the previous implementing regulations promulgated for the 2008 ozone NAAQS and does not contain significant revisions from that previous rule. The 2015 ozone SIP requirements rule addresses a range of non-attainment area SIP requirements New Mexico must meet for the implementation of the 2015 ozone NAAQS, including transportation conformity, non-attainment new source review, emissions inventories and emissions statement, and timing of required SIP submissions and compliance with emission control measures in the SIP. The El Paso Metropolitan Planning Organization submitted a transportation conformity demonstration on behalf of the Sunland Park non-attainment area. They received joint concurrence from the EPA and the Federal Highway Administration by the deadline of August 3rd, 2019. The El Paso MPO is the federally designated transportation planning organization for this portion of Doña Ana County. Pursuant to the 2015 ozone SIP requirements rule, NMED submitted a baseline emissions inventory and emissions statement to EPA by the specified deadline of August 3rd, 2020. A determination of adequacy of Part 79 is due to EPA by August 3rd of this year. If the proposed amendments are adopted by the board, this will be the department's final SIP submittal for the Sunland Park area to fulfill the requirements of the 2015 ozone SIP requirements rule for a marginal non-attainment area. As part of the effort to comply with the 2015 ozone SIP requirements rule, the department analyzed Part 79 to determine if it was adequate to implement and enforce the applicable portions of the 2015 ozone SIP requirements rule. Part 79 was compared with the Federal Clean Air Act regulations at 40 CFR section 51.165 entitled Permit Requirements, which is incorporated into Part 79, and certain inconsistencies and errors were identified. The majority of these are not substantive. However, some are. A detailed explanation of each proposed amendment is shown as NMED Exhibit 5. The proposed changes are intended to bring Part 79 language more in line with federal regulations. The non-substantive changes in the proposed amendments include 5 cross-reference errors and 2 text omissions. The substantive changes include A, the revision of the definition of, quote, non-attainment area, close quote, at 20.2.7.AA NMAC, shown on page 6 of the public review draft. This definition is obsolete. The language comes from the 1977 Clean Air Act, which was amended by the 1990 Clean Air Act. The proposed amended language mirrors the current Clean Air Act definition. B, under the definition of, quote, potential to emit, close quote, referred to as PTE, at 20.2.79.7.A E NMAC, shown on page 7 of the public review draft. The addition of the sentence, quote, secondary emissions do not count in determining the PTE of a stationary source, close quote. The language in this paragraph is based on 40 CFR 51.165, paren A, paren 1, paren III, which was in effect at the time Part 79 was adopted. However, this federal language was left out when this provision was originally adopted into the New Mexico regulation. Nonetheless, the definition of major source at 20.2.79.7 point V paren 6 NMAC addresses this in determining the PTE of a stationary source under this rule. For example, quote, a stationary source shall not be a major stationary source due to secondary emissions, close quote. C, a revision to permit applicability language at 20.2.79.109.A paren 2 NMAC, shown on page 10 of the public review draft. The language in this paragraph is derived from 40 CFR 51.165, paren B, paren 1, and paren 2, but is not verbatim. The proposed amendment would harmonize Part 79 with the CFR. And D, a correction to the specifications for the fugitive emission source category, quote, fossil fuel boiler, close quote, at 20.2.79.119, point B, paren 7 NMAC, on page 18 of the public review draft. The value of, quote, 50 million BTU, close quote, cited in the current rule is incorrect. It should be, quote, 250 million BTU. You're on mute. You're on mute, Andrew.
Thank you. Thank you for that summary of the proposed amendments. What public notification and outreach was provided for the proposed rule amendment?
Stakeholder outreach was initiated on January 29th of 2021 with the announcement of the availability of a stakeholder review draft. Notice was sent via the Air Quality Bureau's regulatory and SIP bulletin listserv to potentially affected parties, outlining the NMED proposal and soliciting comments, shown as NMED Exhibit 4. No comments were received during the informal 30-day comment period. Extensive public notice of this rulemaking hearing was provided as shown in NMED Exhibits 6A through 6K. Public notice was designed with the purpose and the intent to make as many interested persons, governments, and organizations as possible aware of this rulemaking. For example, public notice for the hearing was published in English and Spanish in the Albuquerque Journal and the New Mexico Register, posted on NMED's website, sent via the Bureau's listserv, and sent via email, as well as being posted on the New Mexico Sunshine portal. The department has also complied with the Small Business Regulatory Relief Act, as shown by NMED Exhibit 8. The department does not foresee that the proposed amendments to Part 79 will have any adverse impact on the citizens or businesses of New Mexico. During the public comment period for the hearing, the department received one comment from the public. Wild Earth Guardians submitted a comment to the Office of General Counsel on May 5th of 2021, expressing concerns regarding compliance with public notice requirements, with a follow-up email on May 28th, 2021, reiterating concerns regarding public notice, along with comments regarding the substance of the proposed rule and including attachments. These comments submitted by Wild Earth Guardians and NMED's response are shown as NMED Exhibit 11, as, pardon me, as amended by the first amended NMED Exhibit 11. Wild Earth Guardians filed an entry of appearance with the Environmental Improvement Board on April 7th, 2021, and on June 7th, 2021, Wild Earth Guardians filed a pre-hearing statement with the Environmental Improvement Board that augmented their earlier comments. Wild Earth Guardians raised two objections along with providing proposed amendments to Part 79. First, they alleged that the Environmental Improvement Board did not comply with public notice requirements under 20.1.1 NMAC entitled Rulemaking Procedures, Environmental Improvement Board. Specifically, that Wild Earth Guardians was not directly notified and that notice was not provided on the Environmental Improvement Board website. Therefore, Wild Earth Guardian argues that the hearing should be postponed so that the hearing can be renoticed and another 60-day comment period can be opened. The Air Quality Bureau has complied with all agency requirements for public notice and hearings. stipulated by 20.1.1 NMAC and the State Rules Act at 14-4-1 NMSA 1978. Additional outreach was conducted as outlined in the public involvement plan for the Sunland Park non-attainment area. As outlined in our first amended NMED Exhibit 11, Mr. Timmons, representing Wild Earth Guardians, was present at the EIB meeting on March 26, 2021, where the Air Quality Bureau requested and was granted a hearing date and time regarding EIB 21-07 . In addition, the listserv notice was sent by the Bureau to 5 members of Wild Earth Guardians, including Mr. Timmons and Mr. Nykiel. The certification for adequacy for the Air Quality Bureau's non-attainment new source review rule is due to EPA by August 3rd of this year. Any delay in the hearing date will cause the Air Quality Bureau to miss this deadline. The Air Quality Bureau opposes any postponement of this hearing. Second, Wild Earth Guardians has raised concerns that the proposed amended language at section 20.2.79.109 NMAC could be misinterpreted as excluding ozone from the quote cause or contribute close quote analysis required by statute, and they want to modify the language of Part 79 in an attempt to address this concern. The Air Quality Bureau opposes Wild Earth Guardians' proposed language for 2 main reasons. First, the cause or contribute language already applies to the ozone NACs, both in the CFR and in Part 79, so no rule change is needed. The permitting rules that are currently in place are protective of air quality, including requirements for sources located within ozone attainment and non-attainment areas. When considering ozone impacts, major sources and major modifications, in other words, showing an increase of 40 tons per year of VOCs or NOx, in attainment, unclassifiable, or attainment/unclassifiable areas are subject to PSD permitting rules under 20.2.74 NMAC entitled Permits, Prevention of Significant Deterioration, or PSD, which I shall refer to as Part 74, and require an ambient impact analysis pursuant to Section 303 of Part 74, using air quality modeling tools pursuant to Section 305 of Part 74. Due to the nature of ozone formation, EPA does not set a significant impact level for ozone or for secondary PM 2.5. They have provided guidance that establishes a 2-tiered screening approach for modeling to address impacts. Applicants and the Air Quality Bureau's permitting and modeling groups use this guidance on a case-by-case basis to determine impacts of a specific project. If it is determined that the project causes or contributes to the non-attainment violation, then the permit shall be denied unless the permittee reduces their emissions to compensate for their impact. If their impact is on a designated non-attainment area, for example, Sunland Park, the source would be subject to Part 79, specifically subsection 20.2.79.109 NMAC. Second, the language proposed by Wild Earth Guardians is outside the scope of legal advertisement of this hearing and has not followed the rules and statutes established for a proposed rule change. The proposed language was not provided to the public for public notice for a 60-day comment period, nor was it provided to the Environmental Improvement Board in a timely manner. If Wild Earth Guardians believes a rule change is necessary, they must follow the applicable state rules and statutes for rulemaking. In addition, they would have to submit the rule change to EPA to have the change, if approvable, included as part of the federally enforceable SIP. The Air Quality Bureau submitted the proposed amendments to EPA for review. EPA did not have any negative comments and indicated that the proposed amendments are adequate.
Thank you. Let's see, are there any additional changes beyond those shown in the public review draft that we are proposing to make to Part 79?
Yes. A review by the New Mexico State Record Center found some non-substantive formatting errors that need to be corrected. These are shown in yellow highlight in NMED Exhibit 7.
Thank you. Have there been any, well, let's see. Yeah, since we filed our notice of intent, have there been any new developments in this rulemaking?
Yes. Wild Earth Guardians has since filed a pre-hearing statement on June 7th of 2021.
Okay, and based on our review of that pre-hearing statement, is the department recommending any changes to the rule as we proposed it in the NOI?
No.
Okay, and does our proposed amendment meet the statutory burden in the Environmental Improvement Act?
Yes. The board
How
has
so?
the authority. I'm sorry, go ahead.
Yeah, just go ahead and explain how so.
Yes, the board has the authority to adopt the proposed amendments pursuant to NMSA 78, sections 74-2, -5, B, and C. The proposed amendments do not cause injury or interfere with health, welfare, visibility, or property in accordance with NMSA section 74-2-5.E(1). In addition, in accordance with NMSA section 74-2-5.E(2), the public interest will be served by implementation of the proposed amendments by aligning the current state rule with the federal language governing non-attainment area permitting. Finally, the proposed amendments require no new technology and with no cost associated with the amendments is economically reasonable in accordance with NMSA section 74-2-5.E(3). The factors specified by NMSA 1978 section 74-2-5.E all weigh in favor of adopting the proposed amendments. Hang on, I got to change screens.
Thank you. Go ahead.
This concludes my testimony on the proposed amendments of Part 79. I respectfully request that the board adopt the proposed amendments and set provision at the conclusion of this hearing. Thank you.
Thank you. And for the record, I misspoke earlier when I was referring to the Environmental Improvement Act. My witness was actually referring to the state's Air Quality Control Act. And with that, my witness will stand for questions from the board, and following that for any cross-examination. And again, I offer all four of my witnesses who have been sworn in, I offer them as a panel to answer any questions that might go beyond Mr. Butt's expertise.
Thank you, Mr. Butt, and thank you, Mr. Knight. I believe Wild Earth Guardians now has an opportunity to cross-examine the witness.
Thank you, Madam Hearings Officer. Good morning, Mr. Butt. My name is Daniel Timmons. I'm counsel for Wild Earth Guardians and have some questions regarding your testimony, both pre-filed and what you sort of elaborated on today. So I'll just start at the beginning here. So the amendments proposed by the department relate specifically to 20.2.79 NMAC, correct? I believe you're on mute.
Yes, that is correct.
Okay. And so we've been referring to that as Part 79, right?
That's correct.
And
That's
that's
the vernacular.
and Part 79 is entitled Permits Non-Attainment Areas, correct?
Correct.
And so Part 79 is primarily focused, not surprisingly, with permit requirements applicable in non-attainment areas, right?
That's correct.
And so one of the proposed amendments is to the definition of non-attainment area, correct?
Madam Chair, Madam Hearing Officer, that's correct.
And you described this change as a substantive change, correct?
That's correct.
Do I have, can I be granted access to share my screen? I'd like to walk through some of the department's exhibits with the witness.
Yes, of course. You should now have access. There you go.
Okay. Okay, so I have, can you see what I've pulled up, Mr. Butt?
Yes.
And this is identified as what was pre-filed as NMED Exhibit 1, page 12. Is that right?
That's correct.
Okay, so looking at subsection A, I'm going to read what the current regulatory language shows. And if you could just make sure that I read this correctly, I would appreciate it. The current regulatory language defines non-attainment area as meaning, quote, for any air pollutant, an area which is shown by monitored data or which is calculated by air quality modeling or other methods determined by the administrator to be reliable to exceed any national ambient air quality standard for such pollutant. Such term includes any area identified under subparagraphs A through C of section 107D1 of the Federal Clean Air Act, end quote. Did I read that right?
That's correct.
So is that current definition of non-attainment area limited solely to formally designated non-attainment areas?
Maybe a member of my panel might be better equipped to answer that question. Perhaps Mr. Baca or Dr. Olson.
Sure, Madam Chair, Madam Hearing Officer, members of the board. So
I'm sorry,
that question, can you repeat the question again?
who's
Michael Baca for the New Mexico Environment Department.
Yes, Mr. Baca, the question is the current definition of non-attainment area limited solely to formally designated non-attainment areas?
Well, I believe it does. It's within, it says any area identified under some paragraphs A through C of section 107D1 of the Federal Clean Air Act, which pertains to the designation of non-attainment areas, the process.
Is it specifically limited to those areas, or does it simply include those areas?
Madam Chair, Madam Hearing Officer, you know, I'm unsure of the question. I don't think I have the answer for that. So if I may defer to another member of the panel.
I'm happy to repeat the question if there's someone on the department staff who can help explain what this change is all about.
This is Kerwin Singleton, Madam Chair, Madam Hearing Officer. Mr. Timmons, if you could repeat the question, please.
Sure. With this current definition, under the current definition, would that potentially include areas designated as attainment or unclassifiable, but where monitored data shows ambient air quality to exceed an applicable NAAQS?
Madam Hearing Officer, Madam Chair, I believe that is correct. And Dr. Olson can correct me if I'm wrong.
Thank you, Mr. Singleton. And Mr. Singleton, maybe you can stay on the line here just for a couple follow-up questions on this. So the new definition changes that, correct? And is limited specifically to formally designated non-attainment areas. Am I right?
Madam Hearing Officer, Madam Chair, members of the board, yes, the new definition mirrors the current language in the Federal Clean Air Act.
Thank you. So an area could be designated as attainment. So just sort of as a matter of fact, I guess, an area could be designated as attainment for a particular pollutant, but still have monitored air pollution levels in excess of the NAAQS for that pollutant. Is that right?
My answer is yes.
Thank you. And under the department's new definition, such an area designated attainment, but with monitored levels exceeding the NAAQS, would not be considered a non-attainment area. Is that right?
If it's stipulated as a non-attainment area by the Clean Air Act, which is the language we're accepting to adopt, then that area would be non-attainment as ruled by EPA and would not be a matter of what the monitors are saying per se.
Okay, so I just want to be really clear here. Under this new definition, if an area had monitored air pollution levels in excess of the NAAQS, but was still designated as attainment for that pollutant, it would not fall under this definition of non-attainment area.
Madam Hearing Officer, go ahead, Mr. Baca.
Madam Hearing Officer, Madam Chair, that is correct.
Thank
So
you.
a non-attainment area is only an area that is designated by the EPA. They have to have a formal rulemaking process to designate an area non-attainment. That is a non-attainment area. An attainment area can still have monitored data in excess of the NAAQS and be designated attainment.
Thank you, Mr. Baga. And I'm going to move on from this line of questioning. So I think thank you all for that. I think probably turning back to Mr. Butt. I want to turn to next how the proposed rule change addresses major sources of ozone, particularly in subsection 109 applicability. And so I'm going to turn to page 15 of what was pre-filed as NMED's Exhibit 1. Where did I go? Oh, yeah, okay. Sorry, it's 15 to 16. I got lost for a second. So looking at this language, subsection A applies, paragraphs 1 and 2 describe essentially two different types of scenarios where a permit under Part 79 would be required. Is that right?
That's correct.
And so paragraph 1 applies to major sources or modifications located in designated non-attainment areas where the source would be major for the specific pollutant for which that area has been designated as non-attainment. Is that right?
That's correct.
And that paragraph is not changing, correct?
That's correct.
So under NEBD's proposed modifications, paragraph 2 would apply to major sources or modifications in areas designated as attainment or unclassifiable, but where the new emissions would cause or contribute to a NAAQS violation. Is that right?
That's correct.
So as a general matter, would you agree that it's possible for a new source to be cited in an area designated as attainment, but still cause or contribute to a NAAQS violation?
If it's located in an attainment area and it has a negative impact on a non-attainment area, it'd be subject to PSD, and there would be restrictions on it to compensate for that effect.
Is it possible for a source to be located in a non-attainment area, to a source located in an attainment area to cause or contribute to a NAAQS violation in that attainment area?
My understanding is that there are safeguards in place to keep that from happening.
Okay, so so it shouldn't happen. I appreciate that. But if those safeguards were not followed, it's my understanding that you could cause or contribute to a NAAQS violation in an attainment area in what I would say is two basic ways. First, a designated attainment area which already has ambient air quality in exceedance of the NAAQS, and a new source would come in and make it worse. Is that possible absent safeguards?
I don't know, we're in hypotheticals. I don't think I follow your line of reasoning.
Okay, so looking at the second sentence of paragraph 2. The second sentence of paragraph 2, as proposed to be modified, defines the circumstances where a major source or modification located in an area designated as attainment would be considered to cause or contribute to a NAAQS violation. Is that right?
That's correct.
And that sentence reads, quote, "A major source or major modification will be considered to cause or contribute to a violation of a national ambient air quality standard when such source or modification would, at a minimum, exceed any of the significance levels in subsection A of 20.2.79.119 NMAC at any location that does not or would not meet the applicable national standard," end quote. Did I read that correctly?
That's correct.
And so those significance levels are what are referred to as significant ambient concentrations in 20.2.79.119A NMAC. Is that right?
It's in the table. I'd have to pull the table up, but yes, that the significant ambient concentrations are in that table.
Okay. So under this proposed language, Part 79 would apply to a new major source in a designated attainment area where emissions from the new source would cause ambient air quality impacts above the significant ambient concentrations in that table at a location where ambient air quality does not or would not meet the applicable NAAQS.
That sounds right.
So basically, to cause or contribute to a NAAQS violation as described in paragraph 2 here, a new major source would both need to exceed the significance levels in Part 79, subsection 119 for a particular pollutant, and also be located in an area that already is or would exceed the NAAQS for that same pollutant with the new emissions from the proposed facility. Is that right?
You're gonna have to say that again. I didn't catch that.
Okay, so to cause or contribute to a NAAQS violation as defined in paragraph 2, the new major source would need to exceed the significance levels in that table you described, and also be located in an area that would, that already is exceeding the NAAQS or would exceed the NAAQS with those new emissions. Is that correct?
I think so.
Okay, so I'm gonna I'm gonna turn now to that that table, and this is page 24 of NMED's pre-filed Exhibit 1. I apologize for the scrolling. There we go. And this is the significant ambient concentration table that we were just discussing, correct?
Right.
So for the listed pollutants here, this table establishes a numeric threshold for determining whether a source located in an attainment area for that pollutant would be considered to cause or contribute to a NAAQS violation. Is that right?
That's correct.
But there is no such significant ambient concentration listed here for ozone. Is that right?
That's correct. That table there is verbatim from the CFR, and the EPA does not have, did not list a value in the CFR for ozone.
Okay, so I'm going to go back to subsection 109. Apparently quite long. And really focused in on paragraph 2 here again. Paragraph 2 doesn't address how the department is to determine whether a new major source would cause or contribute to an ozone violation. Is that right?
And not in that language, but as I mentioned before, there's language in both Part 79 and 74, which addresses non-attainment area. If you had a specific question, I could direct it to one of my experts.
We might get there. I just want to focus in on paragraph 2 for now, since this is the change that the department is making. As a general matter, is it possible for a new major source located in an area designated as attainment for ozone, is it possible for that new major source to cause or contribute to a violation of the ozone NAAQS?
Mike, do you want to take that?
I can try. This is Michael Baca with the New Mexico Environment Department again. Madam Chair, Madam Hearing Officer, members of the board. So your question, would you please repeat that again?
Yeah, is it, and I will even say, is it physically possible for a new major source to be located in an area designated as attainment for ozone and cause or contribute to a violation of the ozone NAAQS?
Madam Chair, Madam Hearing Officer, members of the boards, hypothetically, that is possible.
Thank you.
Are you talking about an existing source, or are you talking, I mean, I think we would need some clarification on and context to what you're talking about, because so we can talk about the different permitting programs that you're weaving in and out of with your line of questioning. So I think you're touching on different permitting programs that need to be addressed in a focused manner.
Mr. Baca, for a new major source, major for ozone, located in an area designated as attainment for ozone, would it be accurate to say that as a matter of practice, the department would conduct a case-by-case assessment to determine whether that source would cause or contribute to an ozone violation?
Madam Chair, Madam Hearing Officer, and members of the board, I believe that the department would conduct that screening on a case-by-case basis. And in an attainment area for a major source, they would come in and they would be screened to see what permitting program they would be under. And that could be our, any one of the NSR permit programs. So we have our minor source NSR, we have the PSD program, and those two would apply to the attainment area.
Thank you. So in your opinion, if a new major source for ozone were shown by that case-by-case determination to cause or contribute to an ozone violation in an attainment area, would that source be covered by paragraph 2?
Yes.
Do you believe that is clear from the language of paragraph 2?
Yes.
Okay.
I think one of the words that, it says, so the second sentence that you read, when such a source or modification would, at a minimum, exceed any of the significance levels. So it doesn't mean that that's the only thing we need to rely on. That leaves the door open to other means of screening for the department to make a determination.
Okay.
And I think Mr. Butt referred to this in his testimony when he talked about the two-tiered screening process and the modeled emission rates guidance that EPA provided.
And that EPA guidance is not codified in the department's rules, correct?
No, it's a guidance.
So I next kind of want to touch briefly on why paragraph 2 matters. So I think I'll go back to Mr. Butt to continue. First, if I say paragraph 2 facilities, can I use that term to refer to mean major sources or modifications in areas designated as attainment or unclassifiable that would cause or contribute to violations of the applicable NAAQS? Can I use that as shorthand going forward?
I think I can remember that.
Okay. So 20.2.79 109D, I have to scroll down here just a little bit, entitled Other Requirements. That describes the sections of Part 79 that would apply to those paragraph 2 facilities, correct?
So if it's subject to paragraph 2, it's going to have to also be subject to those 5 other restrictions inside Part 79.
And among those restrictions is that paragraph 2 facilities would need to comply with emissions offsets. Is that right?
That's right.
And paragraph 2 facilities would also need to provide a net air quality benefit in areas where the NAAQS for that pollutant would be violated. Is that right?
I think that's correct.
And paragraph 2 facilities would also need to comply with the Part 74 PSD permitting requirements that you've referred to earlier. Is that right?
If it's major and it's cited in an attainment area and it's going to affect a non-attainment area, it could be subject to 74.
So
it's not an absolute. I'm not a permit engineer. There's a fine point of 79 or 74 or 70 or 72, then I can refer it to my permit engineer.
I don't think we need to get into much further detail here. Just one last question on this point. Would you agree, as a general matter, that subsection 109D imposes additional requirements on paragraph 2 facilities, which are major sources located in attainment areas that would cause or contribute to a NAAQS exceedance, as compared to major sources that would not cause or contribute to NAAQS violations?
we're getting into the weeds. I'll have to defer to Dr. Olson on that one.
Could you repeat that question, please, Mr. Timmons?
Sure. Dr. Olson, would you agree, just as a general matter, that subsection 109.d imposes additional requirements on major sources that would cause or contribute to NAAQS exceedances, those paragraph 2 facilities, as compared to major sources that would not cause or contribute to NAAQS exceedances?
Yes, the additional requirements in this paragraph, Madam Chair, members of the board, the additional requirements in paragraph D would apply to the facilities that are encompassed under paragraph 2.
Thank you. I think that's all I have for you, Dr. Olson. I'm going to turn back to you for just a little bit more, Mr. Butt. Are you familiar with NMED's Exhibit 11 as supplemented or amended?
Yes.
I'm going to pull that up now. Do you see this notice of substitution of exhibit?
Yes.
Okay. Coming down to page 28 of NMED's pre-filed Exhibit 11 as amended. Starting where my cursor is, on line 4, NMED stated, quote, if their impact, paraphrasing, in other words, a new source's impact, is on a designated non-attainment area, i.e. Sunland Park, the source would be subject to 20.2.79 NMAC, specifically subsection 20.2.79.109D NMAC. Did I read that correctly?
That's correct.
And paragraph D was what we were just referring to. Is that correct?
That's correct.
And that applies to the paragraph 2 facilities we were just discussing, correct?
That's correct.
Are paragraph 2 facilities located in non-attainment areas or attainment areas?
Paragraph 2 facilities are in attainment areas.
So looking back at that sentence, starting with if their impact, paragraph D here does not, in fact, apply to facilities located in non-attainment areas, correct?
I guess I have to defer to my panel on that one.
Madam Chair, Madam Hearing Officer, I believe the answer is yes. It sounds like can you repeat that question so I can answer yes or no definitively?
Paragraph D does not, in fact, apply to facilities located in designated non-attainment areas, correct?
Correct. I think we've clarified that paragraph D applies to paragraph 2 facilities as you defined previously.
Okay, thank you. So going down to the final sentence here, NMED stated, if the source's impact is on a designated attainment area, the source would not be subject to 20.2.79 NMAC. Did I read that correctly?
That's what it stated.
Do you agree with that statement?
I don't know.
Okay. But you would agree that the requirements of 20.2.79.109D listed here specifically apply to sources in areas designated as attainment or unclassifiable, correct?
Yes, paragraph 2 is for attainment sightings.
Thank you. Going to move on here. I'm pulling up what is has been pre-filed as Wild Earth Guardians Exhibit 3, and I believe admitted as part of the overall Exhibit 4, and I may need to clarify that. But are you familiar with Guardians pre-filed Exhibit 3?
I'm familiar with the proposed language. I don't know what the exhibit number is.
And that is the red line modifications that Guardians offered regarding NMED's proposal, correct?
Right, I'm familiar with that.
Okay, so looking at the first edit, where we inserted other than the ozone standard, you stated earlier that there is no established significance level for ozone in the reference table. Is that right?
That's correct.
So NMED's proposed language in this section is effectively silent on ozone. Is that right?
I wouldn't say that. If it's major for VOC or NOx, it's also major for ozone.
But
Plus,
again,
as I stated in my testimony, there's language in 79 and in the CFR that addresses ozone. So by putting in this additional language here, it's our opinion that this muddies the water, does not make it more understandable, but makes it less clear. And the language that we propose without your language mirrors the CFR.
But again, there is no significant ambient concentration listed in the table referred to in paragraph 2, correct?
That's correct. It's verbatim from the CFR.
And earlier you did indicate that, or perhaps this was actually Mr. Baca indicated, but the department has indicated that a case-by-case determination is needed to evaluate whether a source causes or contributes to an ozone violation. Is that right?
That's my understanding.
And this final sentence added by Wild Earth Guardians basically says that, correct?
I need some additional help about being declared major for ozone. I defer that to my panel.
Madam Hearing Officer, Madam Chair, members of the board, this is Kerwin Singleton. To address Mr. Timmons' question, we did discuss the proposed language with members of the Environmental Protection Agency in Region 6, and it was their opinion that this language did not make the rule any better. Also, the lack of an ozone sill in the table that was previously referenced does not mean that the department cannot make a determination of whether or not a major source causes or contributes to a violation of the standard. As Mr. Butt previously stated, for major sources, a case-by-case determination is made by the permitting section.
Thank you, Mr. Singleton. One follow-up question on that. In your opinion, for a new major source for ozone, located in a designated attainment area, is the department required to evaluate whether that new source would cause or contribute to a violation of the ozone NEX?
For a new major source of major modification, I believe the modeling guidance would still apply to determine whether or not that source would cause or contribute to a violation of the ozone standard.
The modeling guidance would apply. Does that mean that the department would be required to make that assessment?
For a major source, yes.
Thank you. So turning back to Mr. Butt, just a few final questions regarding the time the board has been essentially given to evaluate this proposal. This rulemaking effort is essentially intended to align the department's regulations with the EPA's regulations that implement the 2015 ozone NEX. Is that right?
It's, well, the way I phrase it is 2015 ozone SIP requirements rule stipulates that certain aspects of the state's air program have to be ship-shape, as I mentioned. So like the emission statement, emissions inventory, and then also you have to make sure your non-attainment new source review program is also ship-shape. And so the Federal Register does not dictate which words to use in this rule. It does say that you need to make sure that your non-attainment new source review program is adequate to enforce the new 2015 ozone NEX. And the way to find out if that is satisfactory, the department took the CFR where all of this language is incorporated and did a line-by-line comparison with the CFR. And anywhere where there's mistakes or things that are unclear, we made them more clear, if that answers your question.
Yeah, and so this line-by-line analysis and aligning the language was done because of the designation of the Sunland Park ozone non-attainment area, right?
It's related to it. I don't know about the causation you're saying, but maybe I'm misunderstanding what you're saying.
And so the Sunland Park area was designated non-attainment on August 3rd, 2018, right?
That sounds right.
And the SIP requirements rule was promulgated by the EPA on December 6th, 2018. Is that right?
It sounds right. I'll have to go back to my testimony if we're gonna have to pin down dates, but for the sake of argument, I'll accept it.
And that's the SIP requirements rule was included as NMED's Exhibit 9C in its pre-filed notice of intent.
Sounds right.
And the state was given 3 years from the Sunland Park designation to adopt conforming rules and submit a determination of SIP adequacy to the EPA. Is that right?
That sounds right.
And so 3 years from August 3rd, 2018 is August 3rd, 2021, correct?
That sounds right.
So that's about a little over a month from now. Is that correct?
That's correct.
And if the submission isn't made on time, EPA could refer to as bump up the Sunland Park area from marginal to moderate non-attainment status, right?
I believe so.
I'm going to go back to NMED's Exhibit 11. And this is page 26. NMED states, starting where my cursor is here, any delay in the hearing date will cause the AQB to miss this deadline, correct?
That's correct.
So this proposal has basically made it to the board for its approval about 2 years and 11 months after a 3-year clock started ticking.
That sounds right.
So there's not much opportunity for the board to have substantive input into this proposal without risking missing that 3-year deadline, right?
I would disagree with that. They were provided a minimum of 60 days notice to consider the matter, plus more time for the petition and also to grant me a hearing. Many, many months they've had this proposal in front of them.
But today's the day where any changes would have to be made, correct?
If they decide not to adopt it as proposed, we will miss the deadline because it'll take another at least 90 days to renotice if there's any language that varies from what's proposed.
Okay, just one more question. Are you aware when the formal public notice for this hearing was finally posted on the EIB's website?
No, I do not.
Thank you. No further questions.
Thank you, Mr. Timmons. Excuse me, thank you. I believe now we can open up for questions from the board. Member Garcia, would you like to go?
Yes, thank you, Madam Hearing Officer. I have a question for Mr. Butt.
Madam Chair, members of the board, I can barely hear you. I don't know if it's on my end.
Oh, okay. Okay, I'll speak up.
There you go.
Can you hear me now?
Yes, that's great. Thank you.
Okay, so this question is for Mr. Butt. Did EPA actually request that you make these regulatory changes?
Madam Chair, members of the board, Member Garcia, it's indicated by the Federal Register and by the ozone SIP requirements rule that we should evaluate our program, along with those other requirements that I mentioned, the emissions inventory and emission statement, and also the non-attainment new source review program.
Okay, thank you. But they didn't request these specific changes to the regs?
No.
Thank you. And a question for Mr. Timmons. With your proposed language, I'm trying to understand the difference that it makes. With your proposed language, do you feel that the department would have more enforcement authority with your language? Would they be able to enact enforcement where they can't with the other language?
Thank you, Member Garcia. I don't believe that it would create new enforcement authority. We see this as a clarification of the existing requirement to assess whether a new source causes or contributes to ozone violations, which we believe is left ambiguous because it's not included in that significant ambient concentration table.
Okay. And one other question for you, Mr. Timmons. The department is saying that their language actually mirrors Clean Air Act language. Are you suggesting that they not mirror the Clean Air Act language?
We are suggesting that they add additional language to make this clarification, which I would also acknowledge that the ambiguity is also generally present in the EPA's language as well.
Also, Mr. Timmons, could you cite an example where the ambiguity may cause a problem with enforcement in the future?
I think the problem would be if that the absence of language clarifying that an ozone assessment is required, that there is a risk that the department could issue major source permits and not conduct that analysis. So it's less of an enforcement issue as a permitting issue, I think.
Okay, I understand. Thank you.
Member Honker, did you have additional questions?
Yeah, just I think a follow-up on Member Garcia's question to Mr. Timmons. Could you kind of walk us through a specific scenario with a new source and what your concern would be with the current wording of the rule change?
Thank you, Member Honker, Madam Chair, members of the board. Yes, the specific concern relates again to those what I was referring to as paragraph 2 facilities. And so these are major sources in areas which are designated as attainment, but still have emissions that would cause or contribute to a NAAQS violation. And so if those if ozone is essentially exempted from that cause or contribute analysis and would not be considered a paragraph 2 facility, then that type of facility would only be subject to the Part 74 PSD regulations and would not be subject to those Section 109, Part 79, Section 109D requirements that we discussed, particularly including emissions offsets and the demonstration of a net air quality benefit. So there would be essentially reduced requirements applicable to these facilities, even though they, because essentially that cause or contribute analysis, if it was not conducted and these facilities were not subject to those particular sections of Part 79.
And if I could now ask the NMED staff to respond to that scenario in terms of how you would anticipate making decisions within the regulatory process.
I would defer to one of my panel.
Member Bitzer, Madam Hearing Officer, Madam Chair, members of the board. So I believe what he's describing to right now is a situation in which the facility would be subject to our permitting rules as a whole. So what he's explaining is that the permit, what we're talking about is the facility would be subject to Part 74 and Part 72, which also have provisions that mirror the language in Part 79 regarding net air quality benefit and emissions reductions. So they would still be subject to other permitting provisions, just not Part 79.
Madam Hearing, I'm sorry, Madam Hearing Officer and members of the board, while the discussion is interesting and useful here, I would like to just step in and caution the board that the procedurally we should be asking questions of the witness who testified, and I know Mr. Timmons can make legal argument, but he's not a witness. He's not been sworn in, and his statements cannot be considered as evidence in this hearing. And with that, I'll leave it to the hearing officer's discretion as to how to address that issue.
I'm going to defer to Ms. Loria. I do believe there's merit in Mr. Knight's statement. And I'm also wondering, is this out of scope for our current hearing? And I would love some input from our other board members, just to check ourselves before moving forward. And if we decide that it is within scope, then we'll go ahead and move forward.
Madam Hearing Officer, I think it's within the board's discretion and fact-finding duty to ask if they need clarification as to things that the department's witnesses have actually testified to, then that's fair game for them to ask questions of that. So as you noted, we don't want to get too far off the field, but if a fact was testified to in response to one of Wild Earth Guardian's questions and a board member desires clarification on that fact, I think that that's appropriate. I do think Mr. Knight's point is well taken that we cannot consider counsel for Wild Earth Guardian's witnesses themselves. So the board should really direct its questions to things that were actually testified to by the witnesses themselves.
Now, I didn't, I'll come right back to you, Member Bitzer. As far as I have seen so far, we are focusing on the information in the pre-filed, I'm sorry, what was the Wild Earth Guardian's pre-filed statement? Yes, pre-hearing statement. Have we wandered outside of that at this point?
I wasn't clear on what the pending question was. I might need, to the extent that you need to be advised on that, Madam Hearing Officer. I think that's really your call to keep the hearing on track. I do, as a general principle, of fuller elicitation of the facts is the preference. And once we become getting duplicative, then I think you're within your discretion to more tailor the discussion. But at present, I would encourage, to the extent that, again, the board members have clarifying questions, that we permit those at this time.
Okay, thank you. I will go ahead and kick that to the rest of my board members, and I will start with Member Bitzer. And I guess just advice to us all to be cognizant of maintaining our focus on what the issue at hand is.
So I'll direct this question to Mr. Butt and his team. I thought I heard in the testimony somewhere that failure to act affirmatively on the department's request here would move us potentially from marginal non-attainment to some other category of non-attainment. But I didn't hear the word moderate, because I thought that was the next level. It goes marginal, moderate, and then serious, severe, extreme. Or did I just mishear that?
Madam Chair, Member Bitzer, that's what I was trying to convey. I don't know if I said it or not, but there's a potential for bump up. It's not, a direct causal relationship. If you don't feel that this is, weighs enough evidence to vote affirmatively, we will not automatically be bumped up to moderate tomorrow. But the sequence of events are marginal to moderate, and we're trying to avoid the bump up. And the one section of our efforts is what we're doing today, which is evaluation of the non-attainment new source review program. And another separate section of the Bureau is working on a 179B demonstration, which is separate, that shows that in our opinion, Mexico and Texas are contributing to the problem, and that also can try and avoid the bump up. I don't know if I answered your question at all.
You did, but what would the consequences be of getting bumped up to moderate?
As you step up, it becomes more onerous. The regulations on facilities become more onerous, and sometimes it can have, as I have in my written testimony, not my oral, there can be sometimes business consequences. The cost of business could possibly go up if facilities have to do more or are under more scrutiny, like in California where they're regulating leaf blowers. So it can get extreme. Once you start climbing those levels, things get more and more extreme and things get more expensive and life gets more difficult.
I hate leaf blowers, by the way, but I'll keep that to my out of my consideration. Thank you.
Do any other members have any questions? Member Sweeney, I think I skipped you at one point.
Madam Hearing Officer, at this point, well, I had an earlier question, but some of them have already been answered, so I'm good for right now.
Member Garcia.
Thank you, Madam Hearing Officer. Just one more item to clarify for me. Mr. Timmons, I think, and correct me if I'm wrong, is suggesting that the reason that they are proposing clarifying language is because you could have a major source designated as attainment, but still cause or contribute to the exceedance of NAAQS and not be subject to Section 109. Is that your worry? I mean, I don't mean for you to testify. I'm just trying to understand.
Thank you, Member Garcia, Madam Chair, members of the board. Yes, that's essentially the concern. And I will also note that I do have a opening statement that I still haven't given. The order of operations here is a little confusing. I was expecting to give that before the testimony. So hopefully that will sort of turn into more of a closing argument, I think, at this point, and hopefully we'll be able to sum things up and clarify any remaining questions.
Okay. Thank you, Mr. Timmons. So with that, then I would turn around and ask the department, any one of the witnesses to answer that concern. Then would it not be subject to 109 in that scenario? Section 109.
Member Garcia, I think that question would best be answered by Dr. Olson.
Member Garcia, could you please repeat that question?
Yes, it seems that Wild Earth Guardians is proposing this clarifying language because they're concerned that a major source designated as attainment, but still cause or contribute to the exceedance of NAAQS would not be subject to Section 109. Would it, in that scenario, be subject to Section 109?
Member Garcia, Madam Chairman, members and hearing officer, yes, I believe that it would be subject to 109.
Thank you very much. I appreciate that. That's all I have.
I actually have a follow-up question to that. Oh, I'm sorry, Member Sweeney, would you like to go?
Yeah, thank you for that, Madam Hearing Officer. So to go a little bit further off Member Garcia's line of questioning, and I'm trying to, get my head around this. It's a lot harder virtually to track everything. So I guess one of the, going back to some of the testimony, I think that was provided earlier by the department, there was a statement, and I can't remember who gave it, about the safeguards that were in place to, you know, address some of the concerns that Mr. Timmons brought up. And I just wanted to see if somebody from the department could share with a couple of examples of those safeguards and those issues that Mr. Timmons brought up. And I think it was safeguards basically along the same line of questioning Member Garcia had about a source located in an attainment area, and either a new source or an existing source, and regarding, I believe, the considerations or concerns regarding that particular source. And I don't know, I think it was under Mr. Baca or Mr. or the legal counsel that was mentioning that. And I just wanted to clarify or get some examples of what those safeguards are.
Madam Chair, members of the board, I believe I had mentioned that, and I think, you know, what I was referring to is that our permitting regulations work together. So we have different parts of our regulations regulate for different scenarios. And I think what I was referring to in the scenario described by Mr. Timmons, that other parts of our regulations would cover that. And I believe a lot of that language would be, you know, it would depend on what permitting program that facility was in, but it would be still subject to similar requirements. And Part 72 actually refers to Part 79 offsets and those sort of emissions reductions. So Part 72, a different part of our regulations, also points to Part 79 for facilities to follow that process in order to be permitted in an area. If they do not follow that process, we are to deny that permit.
Thank you, Mr. Baca. And as another follow-up to that, and I guess a point of clarification to Mr. Timmons, this question is, could you share with or explain further, one, the clarifying language that I think was mentioned earlier? Could you go over that and how that clarifying language may or may not address some of the concerns?
Thank you, Chair Sweeney, Madam Hearings Officer, members of the board. Yes, if you'd like, I can pull up that language on the screen and walk through that. If I get screen sharing capacity. There it is. Okay, I believe that you should be able to see that language now. And so there's essentially two edits that we've made, and both really are...
Mr. Timmons?
Yes.
I'm sorry, I don't believe we're all seeing your screen. Oh, there it goes. Now
is it not showing? Okay.
Yeah, now it looks like it popped up. Thank you.
Okay. I moved it apparently. And so there's two separate edits here, and they're basically both trying to address what we believe is the ambiguity caused by the absence of ozone in that significant ambient concentration table. And so the first edit, where we insert other than the ozone standard, is basically to make it clear that exceeding the significance levels in that table is not how one would demonstrate or evaluate whether or not a major source of ozone violates or causes or contributes to an ozone violation, because there is no significant level for ozone established in that rule. So that is simply just trying to say that you don't, for evaluating contribution to an ozone violation, the department doesn't look at that table, because that table says nothing about ozone. And so then the second, the full sentence that we've added here, for any major stationary source or major modification that is major for ozone, as defined in the applicable regulations, which refer to being major for VOCs or NOx, and will be located within an area designated as attainment or unclassifiable for ozone, a case-by-case determination shall be made to determine whether it would cause or contribute to a violation of the ozone standard. And that language, while not reflected in the CFR, is reflected in the EPA SIL guidance, the significant impact level guidance that's been referred to here, and which mandates that type of case-by-case determination for evaluating whether or not a major source for ozone causes or contributes to a violation of the ozone NAAQS. And so that's what this language is attempting to insert and is reference. And I will note that the department's witnesses here today, my understanding is that this is in fact reflective of what the department actually does. And so we don't see this as again, a real substantive modification as opposed to a clarification of what the department's practice and requirement is.
Thank you for that, Mr. Timmons. So I'd like to maybe have another question and just clarity in my mind with Mr. Baca or the legal counsel on this. So with that language, it seems to me, again, I'm trying to wrap my head around this. It's really the issue with the ozone, but I understand, I think in previous statements earlier during this hearing, that the difference between the CFRs and then the guidelines was something I think Mr. Baca, you had referred to earlier as a difference in how, I guess it was being looked at in terms of the ozone considerations. Is that correct?
Madam Chair, I believe that is correct. I believe you classified that correctly. So EPA themselves have not set a SIL for us to adopt. So we do not have one proposed in that.
Okay. And so given that, let's look at ozone as an example. What are the safeguards that you see would address that in other areas or other permitting rules or regulations or processes that the NMED has?
So for PSD permits, there's PSD increment that would also be taken a look at. There's a whole air quality analysis that is dictated by the PSD regulations. So we would have to undergo that process. And under our NSR permitting program under Part 72, there's also provisions in there that require us to do an air quality screening analysis. And if there is shown that there's non-attainment, there is provisions to either reduce that for that facility to reduce their emissions so that they no longer show an impact, or that they do what's required for permitting offsets under like Part 72. They would be required to get enforceable permanent emissions offsets in order to operate in that area.
And in those cases, Madam Hearing Officer, sorry about the lack of protocol here, Madam Hearing Officer and Mr. Baca, in those cases, is that the issue of the lack of CFR regulations at the federal level regarding ozone versus a guidance? Does those other permitting processes or rules or requirements affect how ozone is, the safeguards for ozone in those other processes?
I don't believe so. I think Mr. Budd had stated earlier in his testimony that NMED still believes that their permitting program is protective of all of the NAAQS standards in every aspect. And that, one thing to point out is all of our programs as they are EPA approved SIP programs. So the language that they are proposing would also have to be adopted by EPA into our SIP, and that would become federally enforceable language. So, I don't want to say how EPA would view that, but inserting policy language into regulation, I don't know how that would play out with EPA approving our SIP adopted rule.
Okay, thank you. Thank you so much for that. I think that's all, Madam Hearing Officer, for right now for me.
Thank you, Chair Sweeney. Mr. Cates, did you have a question?
Yeah, thank you. I guess this would be for the panel or Mr. Knight. So just to follow on this theme that we've been on for a few minutes here, I just to boil down to like a 30,000-foot question. What would it hurt to give Mr. Timmons and Wild Earth Guardians what they want? What harm would that do?
Member Cates, Madam Hearing Officer, other members of the board, I believe we put our SIP in jeopardy for being EPA approved. So that could call into question our primacy for permitting, for non-attainment permitting program. So I think it could cause some issues with the state issuing our own permits.
Well, and so to carry that a little further, and then what? It causes trouble, and then what?
And then EPA, we would have to fix any deficiency in our SIP in order to reestablish authority or primacy to implement that program. So that would mean most likely that permitting would be conducted out of Dallas, Texas, out of EPA Region 6. I believe, I don't know if anyone else on the panel would like to add to that, Member Cates.
Okay, all right. Yeah, thanks. That answers. Thank you.
Member Garcia?
Go back to a point that the department made early on, which was that the Wild Earth Guardians proposed language would not follow rulemaking procedures. If our counsel, Ms. Soloria, could address that, would that, if that's true, would that preclude the board from even considering their language if they didn't follow procedures for rulemaking and public notice, et cetera?
Well, if there was an issue as to whether the public notice was sufficient, then yes, there would be an issue with the board considering the changes. I will, as a matter of procedure, we've opened the hearing. That issue was not argued at the top of the hearing as to whether or not the record should commence. So we're sort of stuck right now in that a record has been produced, the hearing has been proceeded, and I guess to answer your question from a legal perspective, we could continue with the hearing, the board could consider the rules, and yes, if it's determined on appeal that the public notice requirements were not met, then that would be cause for a court, for example, to throw that back to the board, and the process would have to be repeated. But I don't want to testify, obviously don't want to testify on whether or not those public notice requirements would have been met in this case, but that is sort of the legal landscape. Member Garcia.
Thank you very much. I appreciate that. That's all I have.
Okay, any other questions from the board? Oh, Member Sweeney.
Yes, thank you, Madam Hearing Officer. So to follow up on that, and maybe this will be another question for Ms. Soloria, is so right now we have the proposed rule changes from NMED. If there were any amendments, whether or not it was from the Wild Earth Guardians, is there, so right now, I guess I'm just trying to get my head around this. Either we approve of the amended rule changes or not. We don't amend the proposed amendments. Is that correct?
Sabina, it's within the board's discretion whether or not to adopt the amendments as proposed by the department with or without changes. So as if you recall, I think it might be illustrative to use prior rule hearings that we've had. There have been prior rule hearings where a member of the public or a stakeholder has proposed an additional revision to the amendment that has been proposed by the department, or has opposed a particular part of the amendment. And so the board is within its discretion to adopt those as well. So bringing it back to this particular proceeding, Wild Earth Guardians has proposed its own addition to the department's proffered amendments. And so the board can adopt those along with the department's proposed amendments, or it can decline those.
Thank you for that clarification. Thank you, Madam Hearing Officer.
Okay, does anybody else have any questions? Okay, I'm gonna ask some questions now. So circling back, we're gonna circle back a little bit. This question is either for Mr. Baca or Mr. Butt, whoever feels more qualified to answer this, but I wanted to kind of follow up on Mr. Timmons' question about sources, major sources in attainment areas that could violate NACs. Are there any current examples of that right now, or is this a hypothetical situation?
Madam Hearing Officer, I believe that kind of information would probably be best known by Dr. Olson. I'm not sure if Mr. Timmons was referring to a hypothetical situation or if he actually had something in mind, but maybe our permitting section would be more familiar with the types of permits, the applications that they receive.
Madam Chair, members of the board and hearing officer, I am not myself, I am the program manager for Major Sources Permitting. I am not aware of any of those circumstances, but the people who could really describe that would actually be the individuals who work in our modeling group.
Thank you, Mr. Baca and Ms. Olson. So just to clarify, we at this time do not know if there's actually any examples of that situation or if this is hypothetical.
Madam Hearing Officer, members of the board, if I could address that. New major sources and major modifications in attainment or unclassifiable areas are subject to the permitting requirements in Part 74, the prevention of significant deterioration requirements. So we do have a rule that addresses those sources.
So, Mr. Singleton, is it your opinion that this is not a concern, that we should not be concerned about seeing NACs violations in attainment areas for new major sources?
That is correct, because EPA does review permits for new major sources and major modifications. So if their review of our permitting record did not show that the permit was protective of the next, and they would provide comments on that. So the fact is that we have a rule to protect the next.
And just for my reference, what rule is that?
In part, what we're talking about, new major sources and major modifications, is covered by Part 74. Permits for prevention of significant deterioration.
Thank you, Mr. Singleton. I appreciate that information. And then my next question is actually, I believe, for Mr. Knight. It seems that this is the second event that we've had where we are coming up against a deadline for the EPA in which we run a risk of some sort of enforcement by the EPA. Is there, I have concerns about that. We are, as a board, being kind of forced to make a last minute decision on some of these. Is there any particular reason why we're seeing these at the last minute, right before they're due?
Madam Hearing Officer, Madam Chair, members of the board, there are a variety of reasons, which include the public health emergency, but I would say that's probably not even the largest one. There was a lot of litigation over the ozone standard at the time it was promulgated, which wasn't resolved for the first couple of years, and it was really hard for all states, really, but particularly some of the western states like New Mexico to know what we were going to have to do until the whole issue of whether the ozone standard was going to be upheld or not was resolved. And yeah, it took a long time, but once those cases were resolved, then the pandemic happened kind of right on the heels of that. And not to make excuses, but those are the reasons. And in normal times we would have had this hearing a year ago, but that's where we are now.
Thank you, Mr. Knight. I understand it's a different time, but yeah, would love to see some of these a little bit earlier to make sure that we have an opportunity to make any requests or changes or give everything proper consideration. And I'd like to also thank my other board members for asking such great questions and kind of made my questioning a little bit easier. So thank you. Okay, so unless there's any more questions, I believe we can move on to the next portion of this.
Madam Hearing Officer, we would at this time give the audience members or public members an opportunity to ask questions as required by the rules. So our administrator, Ms. Jones, has indicated to me that there's only one caller in. Everyone else seems to be logged in from a computer. Perhaps, Ms. Jones, you could call upon the caller in and ask if they have any questions, and then everyone else who wants to who has a question can unmute themselves, and we'll go from there.
Certainly. Caller 505-269-3862. Do you wish to ask any questions or give any non-technical testimony at this time?
And Pam, are participants able to unmute themselves?
Yes.
Okay.
Yes. Other members of the public, if you wish to do the same, please unmute yourself and speak up. Madam Hearing Officer, Council Solaria, I don't see any indication that anyone from the public wishes to speak.
Thank you, Ms. Jones. Madam Hearing Officer, I think you're set to move on to the next portion. Thank you.
Okay, thank you, Ms. Jones. Okay, moving on. And thank you for the reminder. Okay. We will now hear from Wild Earth Guardians. Does Wild Earth Guardians wish to make an opening statement or as a closing statement, as Mr. Timmons indicated?
Thank you, Madam Hearings Officer. Yes, we would like to make a statement at this time. I don't anticipate offering another one later on, so we can call it an opening if we'd like, to keep the record clean. So good morning, Madam Chair, Madam Hearings Officer, members of the board. Again, Daniel Timmons on behalf of Wild Earth Guardians, along with my co-counsel, Matt Nykiel. Wild Earth Guardians is here today to make sure that this rulemaking process does not result in the creation of a loophole that would exempt new sources of ozone pollution from the required demonstration that new emissions not cause or contribute to exceedances of federal ozone standards, a loophole that would threaten air quality and public health in New Mexico. Because our concerns are essentially issues of legal interpretation, we have not offered and will not be offering technical or other additional witnesses. And so I appreciate the opportunity to offer this statement to explain our concerns with the department's proposal, which should take less than 10 minutes. The Clean Air Act requires major source permittees to demonstrate that their emissions will not cause or contribute to air pollution in excess of any National Ambient Air Quality Standard, or NAAQS, in any air quality control region. This requirement plainly applies to permits which will cause or contribute to exceedances of the ozone NAAQS. And from both the response to Guardian's comments in this matter, as well as Mr. Singleton's testimony here today, it is our understanding that the department also recognizes that this basic cause or contribute standard applies to the ozone NAAQS. That said, however, we remain concerned that the department's proposal could be misinterpreted as excluding ozone precursor emissions from that cause or contribute analysis required by the Clean Air Act. Specifically, the proposed regulatory language ties the cause or contribute threshold to specific significance levels contained in the board's regulations. That was the table we looked at. But again, there is no significance level for ozone established by the board's rules or by the EPA's rules. So the proposed language could potentially be read to imply that the cause or contribute standard does not in fact apply to ozone. Such an interpretation or misinterpretation would violate the Clean Air Act's cause or contribute requirement, as well as federal regulations mandating that state implementation plans also require that same demonstration that new major sources not cause or contribute to NAAQS violations. This would also conflict with the board's existing rules, which require permits to be denied where a new facility will cause or contribute to any NAAQS exceedance, which includes ozone. If the proposed regulatory language were so interpreted to imply an ozone exemption from the cause or contribute requirement, this would violate the Clean Air Act, jeopardize EPA's approval of the New Mexico SIP, and threaten public health. Guardian's concern regarding the potential for misinterpretation of this proposed language is heightened by the board's recent decision indicating that the board lacks the authority to deny minor source permits based on ozone impacts. As the board stated in its final order in EIB case number 20-21, quote, "The department does not have authority or discretion to deny a permit or require offsets for an individual new or modified minor source in a designated attainment area on the basis that the facility will cause or contribute to ozone levels above the NAAQS. And that's included as Wild Earth Guardian's pre-filed Exhibit 1. While that EIB decision related specifically to minor source permits, not the major source permits at issue in the current rulemaking, it still raises real concerns that this new regulatory language could also be interpreted in a similar manner and exclude major sources of ozone from the cause or contribute analysis required by the Clean Air Act. Absent a significance level established by rule, the department is required to make a case-by-case determination whether a proposed new or modified major source will cause or contribute to ozone violations. And EPA has issued guidance regarding significant impact levels, or SILs, to help permitting authorities, like New Mexico, in assessing whether a proposed source would cause or contribute to an ozone NAAQS violation. And that EPA guidance is attached as Wild Earth Guardian's pre-filed Exhibit 2. While non-binding, the EPA SIL guidance makes clear EPA's position that the cause or contribute standard applies to ozone, and that, quote, a determination that a proposed source does not cause or contribute to a violation can only be made by a permitting authority on a permit-specific basis after consideration of the permit record. Guardian's red line modification, pre-filed as Wild Earth Guardian's Exhibit 3, is intended to clarify just that. Absent a significance level for ozone established by rule, a case-by-case determination is required to demonstrate that a new major source would not cause or contribute to an ozone NAAQS violation. The department's testimony here today appeared to indicate that this case-by-case approach to assessing ambient ozone impacts is in fact the department's practice for evaluating major sources. So from Guardian's perspective, the department's opposition to our proposed modifications appears to be based less on the merits of that proposal than on its timing, particularly given the impending August 3rd deadline for the state to certify its updated state implementation plan to the EPA, including the amendments currently before the board. As the department's response to Guardian's proposal indicated, any delay in the hearing date will cause the AQB to miss this deadline. So in light of that deadline, just over a month out, Guardians recognizes the difficult position in which the board now sits, being essentially forced to choose between meeting this mandatory deadline or taking the time that may be needed to make sure that you get it right. But taking a step back, it's critical to remember that under the Environmental Improvement Act and the Air Quality Control Act, this board is responsible for promulgating rules to manage air quality in the state and ensure compliance with federal air quality standards. While the board typically adopts rules in response to proposals from the department in fact has no formal special powers or authority in this rulemaking process. This board, not the department, is the rulemaking authority. And as the Environmental Improvement Act states, the department proposes regulations, quote, on the same basis as any other person, and may participate in rulemaking proceedings on the same basis as any other person, quote, but shall not be given any special status over any other party. The statute is clear. This board is not, and is not intended to be, a rubber stamp. And yet, once again, the department has waited until the proverbial 11th hour, or more specifically, nearly 2 years and 11 months into a 3-year window to finally get its proposal before you. And unfortunately, the department's delay has now left the board with little room to move, little room to assert its statutory authority over this rulemaking process, and to take the time needed to fully vet the department's proposal and identify potential ways to clarify and improve the proposed rule. I'll also note that this delay meant that there was really no chance to extend this hearing date, even though the public notice required by the board's regulations was not put up on the board's website 60 days in advance of this hearing, as specifically required by the board's rules and evidenced in NMED's Exhibit 11. To conclude, Guardians request that the board adopt our proposed red line modifications to clarify that these rulemaking amendments do not establish a loophole for ozone. At minimum, however, we ask that the board take a hard look at the department's proposed language and Guardians' concerns regarding potential misinterpretation of that proposal. And we ask that the board make clear on the record here today that this rule does not create an ozone loophole, and the department is still required to assess whether in areas designated as attainment, new major sources or major modifications would cause or contribute to violations of the ozone NECs. Thank you for your time and attention. And my only final matter would be to make sure that Wild Earth Guardians pre-filed exhibits 1, 2, and 3 have been admitted to the record. I believe that they were included with our pre-hearing statement in the earlier admission. Thank you.
Thank you, Mr. Timmons. As for the exhibits, I apologize. I lost my place here on the script.
Madam Hearing Officer, you can just ask if there are any objections to the admission, and if not, or after consideration of saying, you can roll those admitted.
Thank you. Are there any objections to, are there any objections? Okay, go ahead and admit those to the record. Okay, now we will hear any non-technical testimony or take written statements from members of the public. Any testimony must be limited to the proposed amendments. The board is unable to take any testimony unrelated to the proposed amendments. Ms. Jones, do we have anybody who's emailed or messaged you for the statements?
No, I have received no email notifications of anyone wishing to make any kind of a comment. And members of the public that are on the call are free to unmute themselves. Madam Hearing Officer, I don't see anyone indicating that they wish to make any kind of a statement.
Okay, thank you very much. Okay, moving on. Let's see, we're going to skip a few bullet points here to get to
And I'll interject, Madam Hearing Officer. We don't need to cover the portion of potential rebuttal testimony because there was only testimony in chief from the petitioner itself. So you could invite closings at this time.
Okay, great. So I would like to thank the board and everyone for their participation today and their patience. And I understand how difficult it can be working on virtual platforms sometimes. A quorum of board members did.
Sorry, I was not clear. You could invite closing argument before we close the record.
Oh, okay. So would anybody, is it open to anybody? I'm sorry, I seem to be totally off script here.
That's okay. So the department in terms of order, it doesn't appear that Wild Earth Guardians will be offering another statement as indicated by Mr. Timmons.
That's right.
But we would invite Mr. Knight to make a closing argument if he would like to do that.
Mr. Knight, would you like to make a closing argument?
I would.
Thank you. Floor is yours, sir.
Wild Earth Guardians acts like their proposal is important, and maybe it is important to them, but to the rule, it is not important. It is superfluous, it is unnecessary, and it adds nothing to the rule. But what it does do is endanger the approval of our SIP and risks losing primacy for our air quality permitting program. And Wild Earth Guardians, their argument really isn't with NMED. It seems like to me that their argument is with EPA, and they would like, EPA to change their rules, or they would like Congress to change the Clean Air Act. But neither one of those things is within the power of either NMED or this board. And the proposal we put forward today complies with federal law. It has, EPA has indicated as much as they can before it is formally submitted that it complies with their requirements. And we are confident that it will be approved by the EPA. We cannot say that about the language that Wild Earth Guardians is proposing. It has not been subject to public comment. It has not been part of the public notice for this rule. And the risk of some other stakeholder challenging it and successfully getting the whole rule amendment thrown out is, in my opinion, pretty high. So a completely superfluous and unnecessary change versus, the risk of, frankly, our whole permitting program. I don't see, how that makes sense at all. The misinterpretation that Wild Earth Guardians is concerned about, in terms of their arguments about that, they're correct. It would violate the Clean Air Act. It would violate our own regulations. And so that's not something that the Air Quality Bureau is going to do. And we've been clear in our testimony that that these, major sources and attainment areas are regulated by a separate part 74, and there is no ozone loophole. There never has been, and there isn't going to be in the future. I mean, the language that they are proposing, by itself, at worst might be harmless, but it doesn't add anything to the rule, and it potentially creates very significant problems which have very real world consequences for New Mexico. So I would urge the board not to create those risks unnecessarily. And the proposal we've put forward today is approvable, and it complies with the requirements, and there's no reason to depart from it, in our opinion. So with that, we urge the board to adopt our proposed amendments as laid out in the NOI, and we thank you for your time today.
Thank you, Mr. Knight. Okay, now on to the next portion here. Again, I'd like to thank everybody for their participation today. A quorum of the board members did attend this hearing. The hearing notice indicated that a decision might be made at the conclusion of the hearing. The board may immediately deliberate or decide on the proposed regulatory change at the conclusion of this hearing. So unless there are any other questions or issues, the record of this public hearing will be closed. So last opportunity. Okay, the record is now closed. Let the record show that the hearing was adjourned at 11:50 a.m. So I believe now it's time to turn it to the board to ask whether we want to deliberate today and make a decision, or if we want to do this at another time. So I'm opening up to the board members for discussion on that. Mr. Bitzer?
If I may interject, the reporter, since the record's been closed, the reporter is off now. Thank you.
So I'm torn on this one. Looking forward to what everybody has to say. Although the one point I would like to make is that I think we should, whatever decision we make, we should make it today.
I would second that. I'm not that torn on it, and we spent a lot of time on it already. Time is of the essence here in terms of the deadline, and if everybody has it in them, I think we ought to deliberate and do a vote today.
Yeah, Madam Chair, I agree. This is Ben Duval. I would motion to vote is, today.
I concur as well.
Member Garcia, I see the thumbs up there. Member Sweeney, I hadn't heard from you. Just checking in. Thumbs up, got it. Okay.
Point of information, real quick, are we supposed to still be in the hearing? Amanda, if you're chairing, it feels like we're in the hearing. Shouldn't you turn it back over to Phoebe?
Oh, fair point. Thank you. Yes.
Council, am I off on that, or is that right?
Yeah, that's on point.
Okay, thank you. Thank you. Happy
All
to turn it back over. There you go, Member Sweeney.
Thank you, hearing officer, Madam Hearing Officer, appreciate it. And thank you for that point of clarification, Member Bitzer, appreciate that as well. So yes, so now that it sounds like we're all on the same page here with regarding to deliberation today. Is that right now, I mean, we're at 11:53. Are we good to continue till we deliberate and come up with a decision? Great. Okay. Let's see. Okay. I'm going to read from the script too. Since we're deliberating today, the board will immediately deliberate to make a decision on the proposed amendments. If, while deliberating, the board determines that additional testimony or documentary evidence is necessary for a proper decision on the proposed amendments, the board may, consistent with due process requirements, reopen the hearing for such additional evidence only. So again, just as we go forward with our deliberation, I just wanted to make sure I state that as we continue. And let's see, making sure legal counsel, Solaria, make sure I'm on board too with this. I've reviewed this before the meeting to make sure, but it looks like that's pretty straightforward for all the hearing script. And then I guess we can just open up for discussion at this point.
Correct, Madam Chair. At this point, if the board has elected to deliberate because it was noticed in the hearing, the notice for this hearing, the board can go ahead and deliberate at this time.
Thank you so much, Ms. Solaria. So the floor is open. Board members for discussion. Yes, Mr. Member Honker.
Yeah, I'm I think Member Bitzer said he was a bit torn on this. I'm a bit torn on this. I see Wild Earth Guardians issue. If I thought it was a serious or fatal flaw with the proposed rule change, I'd be the first one to say we should send it back to NMED or add some language. I think we discussed this issue very thoroughly. There were a lot of hypotheticals discussed by Wild Earth Guardians and the NMED staff. We've had numerous assurances that the scenarios that Wild Earth Guardians were concerned with would be adequately addressed. Ozone would be addressed through the permitting process. So I do think if we elected to go ahead and adopt the additional language that Wild Earth Guardians proposed, that would be a bit risky because it has not been thoroughly vetted with stakeholders, much less EPA. We can't be sure what EPA's reaction to that would be. So to me, it's less risky and the better course of action to adopt the language as proposed. Just because I'm not seeing a real world tangible issue here that seems to be on the horizon. I think I'm coming down on the side of adopting the language as proposed and petitioned by NMED.
Thank you, Member Honker, for your comments. Yes, Member Garcia.
Thank you, Madam Chair. I guess to echo Member Honker's statements, I also am always interested in clarifying language on regulations, particularly the air quality regulations are some of the more complicated regulations I've ever seen. And anything that clarifies is always a good idea. However, through my questioning, what I learned is that it doesn't necessarily clarify because it sounds like for a major source that's in a designated attainment area, it would still be subject to Section 109. And that seemed like it was the concern, but NMED staff said, I think it was Ms. Olson said, yes, it would be subject to Section 109. So I guess there's, it doesn't sound like the scenario that Wild Earth Guardians is concerned about would happen as far as I can see. But I was heartened, just to mention, I was heartened that the department did in fact show this Wild Earth Guardians proposed language to EPA. At least that's, unless I got that wrong, Kerwin Singleton mentioned that they showed the proposed language to EPA and EPA did not think that the language was clarifying. At least that's the statement I wrote down from Mr. Singleton. So I am heartened that they didn't outright dismiss Wild Earth Guardians language. They actually looked at it, presented it to EPA, and EPA said, no, this doesn't help. So, so I think that my opinion is that perhaps there's concern that doesn't need to be there. And not to mention the risk of losing primacy of the permitting program, that's pretty serious. But if this language really did clarify a need that needed to be clarified, I would be willing to take that risk if it really needed to be clarified, but it doesn't sound like it does to me. So, so that's my feeling is that we should go ahead and adopt the proposed rule changes that were agreed upon by EPA that NMED proposes.
Is there, yes, Vice Chair Trujillo Davis?
Thank you, Chair Sweeney. I think I'd like to echo my other board members in saying that I'm very torn in this decision as well. I think that Wild Earth Guardians did bring to light some very valid points and concerns. But I am concerned that if we were to adopt the language that they proposed, that it wasn't fully vetted as far as public goes. And it would be it would be risky to adopt it as it's proposed, or as their language is proposed now. But in saying that, I'm also concerned that we are being asked to make this decision at the 11th hour, and that we're opening ourselves up to maybe not looking at the issue completely. Although I understand I'm kind of flip-flopping here on this, but again, it was a very torn decision. You know, I believe the risk is low, and for that, I think we should approve as the NMED has proposed. But again, I would caution the NMED on doing some of these at the last minute.
Thank you, Vice Chair Trujillo Davis, for your comments. Appreciate those. Any other members have any additional comments as we deliberate on this and discuss? Thank you all. And I just to add, I wanted to also say I'm torn a little bit too, in that, as Member Garcia mentioned earlier, the air quality rules and regulations are very complex. And in addition to, we have the recent passing of a law amending the No More Stringent Than, which I'm sure we'll start to see other proposals regarding that change in the law earlier this year at the state level. And so, you know, I know that, you know, we're trying to figure out, you know, where we look at this particular proposed rule change, but also we have to look at, you know, the overall programmatic and other issues, collateral issues. And as Member Garcia stated earlier, the primacy of the permitting program is important, especially if, again, this new law has been amended, or the law had been amended for air quality rules and regulations here in the state of New Mexico. So it's important, I think, also to support NMED in keeping that permitting and that regulatory role here at the state level. But that said, as to what Vice Chair Trujillo Davis stated, as Wild Earth Guardians, Mr. Timmons did provide some good points of consideration, also in regards into what we saw in recent decisions regarding the minor sources. And as we know, you know, the rules and regulations on how they fit together from the federal to the state level, we're always trying to navigate that and making sure that we do have rules and regulations that do protect our the citizens of New Mexico, as well as the environment, which is something that I think is extremely important. So with that said, but that said, I think some of the statements, as Mr. Kerwin mentioned, about proposing the amendments that Wild Earth Guardians have proposed, really have already been, there are existing permitting process and rules or regulations under section 109 in particular that would address and ensure that there's a check in place, if you will, something, a safeguard, I think is what Mr. Baca had stated earlier in his testimony. So yeah, so I don't know, with all of that, I think as we navigate this and as we navigate the landscape of the air quality rules and regulations, I think, you know, how they fit with the federal and state, how state and federal fit together is going to continue to be something we need to look at. And to what member or Vice Chair Trio Davis stated is, if again, we're all coming out of this pandemic situation, so there are extenuating circumstances, but it does help if we have a little bit more lead time so that we can consider further amendments. You know, and I know I was up late reading a lot of stuff over this last week, so processing all the information. But that said, I do appreciate all that information to try to make a good decision, I should say, as we consider all parts. I don't know if anybody else has anything else to say. Yes, Member Bitzer.
I want to say that I appreciate Wild Earth Guardians. I'm grateful that they are here because otherwise I fear that we might, for lack of a different perspective, get pulled into that rubber stamp mode that they express concern about. And I certainly don't want us. I don't think we have been. I think we demonstrated that back over last year with the state's requests on extending their time for toxic waste permits. But without them, we would be in some danger, I think, of not having that binocular vision and having a different perspective. So I want to say that I appreciate them very much.
Thank you for that, Member Bitzer. I appreciate that. Yes, Member Cates.
Yeah, just to add to the echo chamber a little bit here, I basically say the same thing that Member Bitzer said there, in that I really do appreciate the Wild Earth Guardians and their, I think they know this statute as well as anybody, and you know, I would hope that they would continue to engage the board on issues as we go forward.
Thank you, Member Cates. I appreciate that. With that, so I think we've heard from most of the members. Member Duval, I think, I don't know if you have any other comments. I don't see the video, but I just want to double check that.
No, I agree with pretty much everything that's been said. I have nothing else to add, I guess would be the cleanest way to say it.
Thank you, Member Duval. Appreciate that. With that said, I don't know if we want to move to somebody making a motion or further deliberation or discussion.
Well,
yes, Member Garcia.
I can make a motion to proceed with the vote.
Okay, yes. Yes, do I have a motion? So Member Cates, you're saying you have a motion to proceed with the vote?
Yes, ma'am.
Okay, and I think we might need to clarify, proceed with the vote on passing the amendment as proposed by NMED, or I don't want to put words in anybody's mouth, but just a clarification on the motion.
So my motion is to proceed with the vote on the amendment as cast by the state. How's that?
Thank you, Member Cates. Appreciate that clarification. Do I have a second?
I'll
yes.
second.
Member Honker seconds.
I think, Madam Chair, just for clarification, I would, and Member Cates can interject, but just to clarify the motion, is the motion on the floor to adopt the amendments as proposed by the department without change?
Yes, it is. Do I need to say that? So the motion is to adopt the the rule as proposed by the department without change. Yeah.
Thank you for that clarification, Member Cates.
And I will second that clarified motion.
Thank you, Member Honker. Appreciate it. With that motion on the floor and just looking around one more time for no added discussion or deliberation, debate. I don't see any. So with that said, Ms. Jones, I'm going to look to you to see if we can do a roll call vote on Member Cates' motion and Member Honker's second.
Yes. Beginning with Member Bitzer, how do you vote?
Yes.
Member Cates?
Yes.
Member Duval?
Yes.
Member Garcia?
Yes.
Member Honker?
Yes.
Member Trujillo Davis?
Yes.
Chair Sweeney?
Yes.
Madam Chair, the motion passes.
Thank you, Ms. Jones, for that roll call vote. I appreciate that. Yes, Member Bitzer?
Did we lose Dr. Duval? I don't think she called him because he wasn't here initially, but he came in.
No,
pretty early.
I'm here. Sorry, I apologize. I had some grad student related emergencies this morning. But yeah, I'm here.
So shouldn't he be allowed to vote on this as well?
And I just did.
Oh, I'm sorry, I missed that. Okay.
Thank you for that clarification, Member Bitzer. Appreciate it. Great. Well, we do still have the next public hearing. So it's 12:12. And I was just wondering, Ms. Solario, is this a good time to maybe ask if we want to break for lunch?
Yes, that would work at your discretion. I'll also note there's just a little sum up language that the board will issue its decision in writing and include its reasons for action taken. And the board administrator will provide notice of the board's action to each participant of this hearing and to those who have made a written request for that information. So I'll just add that to round out that last hearing. You can call for a break. For the board's information, we have a separate link for that hearing. So we would, if we do take a recess at this point, we would log off completely of this link and log into that second one starting at 1 p.m.
Thank you for that. Again, point of clarification, I'm going to look to you, Ms. Solaria. Do we have to vote to go to break and then come back in, or is it just?
No, Madam Chair, you can just call the recess at your discretion.
Okay, thank you.
Point of information, if I might, Madam Chair.
Yes, Member Bitzer.
Did we post a specific time for the public to come in for that second hearing? Like, is it 2 o'clock or 1 o'clock?
It's 1 p.m.
Okay, it was specified for 1. Just wanted to make sure we weren't going to leave people not showing up online at the right time.
Thank you for that. So if I may, just propose to our board that we have a lunch until 1 o'clock to align with the public hearing for EIB 21-09. Is that okay?
And just to clarify, so we need to leave this meeting and then re-log in with the other link. Is that correct?
That's correct. Yes.
Okay. Sounds good.
Great.
And sorry to be a stickler. Again, this is a product of the Zoom era. The meeting, we have the meeting and the 2 hearings. The meeting was opened with this link. So Pam, is your intent that we could go back into this link once that hearing is closed? There could be members of the public still here for the meeting. And I open that up, I guess, for input, whether we should come back into this Zoom after the second hearing Zoom. as if we were coming back into a physical location where the meeting was taking place.
Yeah, the joys of virtual meetings.
I will just, again, just only because the agenda, the way it was listed, it said the Zoom link for 9 a.m. meeting and hearing on EIB 2107, which is what we just heard, is a Zoom link, and then it has a Zoom link for 1 p.m. hearing. So I think, as a matter of precaution, we'll let everyone right now know on the call that we will be exiting this meeting to attend the other hearing, and we will be coming back onto this link.
Oh, sorry to interrupt, Carla, but I received 2 links, so there was a separate link for the afternoon session.
Correct. My issue, just as a point of making sure we're minding our P's and Q's, is that on the agenda, this link was the only link associated with the quote unquote meeting.
Okay, I see.
So that's something to consider. I'm putting it out there so anyone on the call is aware of that once we conclude the hearing, as a matter of form, we will come back onto this link to close.
Okay, yeah, that makes sense. That makes sense. Thank you.
Sure.
And in the meantime, I don't know if this is possible. I've seen it on other Zoom meetings, is we could post like in the chat, or I don't know how they did it, that we will be coming back in case somebody does come onto the Zoom link here.
Can we
I don't
do
know if
that?
that's possible.
Is what I had suggested even possible, Pam? I don't know if you have this initial link running long enough to do what I had suggested.
No, I am not sure. We can, you've announced that we're going to come back to this link, leaving it open while we go to the other one. I'm not sure that's possible, given OPF has one Zoom license.
Okay.
I don't think it's necessary to leave this open, but I want to make sure we can relog on to this link. We would close out of this, and when we continue the quote unquote meeting, we could come back to this initial link.
My understanding is we can come back into this link.
Okay. With that being said, at the chair's call, we can close out for now, and we would all reconvene at 1 o'clock on the second link.
Okay. Is everybody good with that? Great. Appreciate it. And I see your head nodding yes, Member Duval, behind your name. I'm just kidding. So I look forward to seeing everybody at 1 o'clock on the second link for the EIB 21-09 hearing. And so we'll have some good lunch, and we'll see y'all then. Okay.
It always likes to give us an announcement.
And Ms. Jones, is member Duval, is he
Duval.
Val,
Val.
Prevail.
Duval, right.
like Valerie, the start of Valerie. I haven't noted it here now.
There you go.
Is he coming up?
He has not he hasn't rejoined yet, no.
Okay. I know people always pronounce my names wrong, first and last, but I'm glad he corrected.
You mean it's not Foebe?
Right?
Pohebe?
Ohibi, yeah. I've heard numerous ways of saying both my first and last name. But well, we do have a quorum. I was hoping Member Duval would be back just so that we can get his input if we need to on the next meeting on July 23rd, 2021. But just in essence of time, I know we've been on, oh, there he is. Great. All right. Looks like we're all here again. And so the next agenda item is discussion about our next meeting on July 23rd, 2021. Does that still look good? Do we have any agenda items yet? Ms. Jones or Ms. Solaria?
Yes, we do have one so far.
There is the one item, a petition that was filed that we, with the petitioner's agreement, bumped from today's meeting to next meeting to consider. And that was a request for a hearing regarding vehicle emissions. So that it may take some time to hear that. I don't expect it to take all day, but we do have at least that one pending item. The other, if you would permit me, Madam Chair, there had been inquiries from members, particularly Member Honker, about doing an ethics training ahead of the large rulemaking. I haven't had an opportunity to do that with this board. I did actually just receive yesterday a few dates for ethics training that the State Ethics Commission is conducting. So with your permission, Madam Chair, I was going to go ahead and forward that to the board. I did attend a session that they did a couple weeks ago just to see what it was all about. And it is more in depth than the training I had intended to do. And I think it's well timed given the upcoming hefty rulemaking that we have. So again, with your permission, I'll go ahead and forward that invitation to the board fully.
Thank you so much. Yeah, I think that will be helpful. And I appreciate you asking about that, Member Honker. Okay, is there any, yes, Member Garcia?
I didn't see a time written next to that, but I would ask that we default to a 9 o'clock start time for the rest of our meetings if we could. And then if necessary, change it. But if we could have that as the default, that would be wonderful.
Great, thank you for that suggestion, Member Garcia. Any other members have any comments regarding that? Member Bitzer, thumbs up. Member Honker, thumbs up.
Yeah, I would be in support of a 9 o'clock start date. I will say if for the July 23rd, I will be on personal travel, and we'll work around that. I mean, I might have to call in on my phone or something, but I think I can make that work. But we're driving back to Chicago for family reasons, and it might be a little challenging, but I think so 9 a.m. would be 10 or 11 depending on which time zone we're in. But yeah, I would support earlier rather than later.
Thank you for your comments. Anybody else have any other comments on that? If not, I think that's a great suggestion. Yes. Somebody comment? Oh, yeah, so let's make the meeting for July 23rd at 9 a.m.
I'm sorry, I got kicked off there for a couple of minutes. Is that meeting on Zoom or is it in person?
Great question.
Just to chime in on that, as I mentioned previously, you among yourselves can decide if you want to meet in person at this point. There are a couple things to consider. One, if we would have a facility to accommodate that, again, depending on your tolerance for spacing and all of that. Two, anecdotally, what I've heard from other clients of mine and other boards and entities is the biggest issue is that even if you decide to meet yourselves in person, it may not be possible. Well, I guess that it would need to be considered whether or not you would want the public there as well, whether that could be accommodated in the physical facility that you choose. And if not, then the meeting would have to be broadcast to them somehow and allow them to participate. And that is technologically harder than having everyone log into one link, because essentially you'd have to have a camera set up, have a screen. I'm sure you all can picture it now. So I don't know, Pam, if you've heard anything from your office about that. Many of my clients have been asking the same question. None of them have ripped that Band-Aid off yet and tried it. So
My understanding is no decision has been made, and I guess we'll take it on a case-by-case basis. If there's significant public interest and everyone wants to be together, we'll have to work on those kind of accommodations.
And in terms of notice, we would have to notice where and how the hearing takes place 10 days before the 23rd. So a decision would have to be made at least by then, which is really not that much time. So
if I may chime in on that topic, I think Carla makes a great point, and maybe the next meeting is a little too soon to try to do a hybrid approach, but I certainly, so I'm a professor at New Mexico Tech, and we are moving towards these kind of hybrid approaches, and it certainly can be done, but I mean there are technological challenges to get there. I think this is something that we should sincerely think about for August meeting, September meeting, like ongoing. How are we going to meet in person as a board, but then also make some sort of Zoom or recording available to the public? And I think that that's absolutely possible. I don't know that within a month that's reasonable to do. I don't. Is that making sense to everyone? This is something that everybody's confronting right now, and especially, I mean, we're working it out in higher ed, and so there's definitely models to go through with that. But I think for the July meeting, it's probably better to. I mean, my personal opinion is that it's better to stick with the Zoom format for the next meeting, and then let's get creative as far as moving forward. I will not be in person on July 23rd, but I would enjoy going back to the in-person format. I would really like that. I don't think that in a month we can do it. That's just my 2 cents.
Thank you for that, Member Duval. Yes, Member Cates.
So yeah, I just have a thought on that. And I agree with Member Duval, just generally. And so COVID has put us in a situation here where public meetings are sometimes cast as problematic now. And I mean, this does, it raises barriers and issues and hurdles, and et cetera. But it's also an opportunity, I think, especially in a state like New Mexico, where we're often 4 or 5 or 6 hours drive from Santa Fe, and that some hybrid solution where we get together in Santa Fe or whatever, and open up the Zoom line so that people who don't have the means to attend in person can take part.
Thank you for that. Thank you for that comment. Member Bitzer has his thumbs up. Yes, Member Bitzer.
You're muted.
You're muted, Member Bitzer.
I would also concur that July is too soon, and we already know we have a board member who can't make it in person. So we definitely want to accommodate him. And but yeah, I too want to get us all back together when we can, and pipe the remote or otherwise restricted portions of our audience, of our stakeholders, so that they can participate as well. It's easy to do. We do it around here a lot. So we do it every Sunday and every Wednesday, actually. So not hard.
Thank you, Member Bitzer. Yes, Member Garcia.
Yeah, just to remind everybody, September is already going to be Zoom, so we're already established. We're committed to that. That can't change. But after that, maybe we can reevaluate.
There you go.
Thank you. Excuse me. Thank you, Member Garcia. Yeah, I think just real quick, my 2 cents is, and I've been sitting on also serving on the Economic Recovery Council, and just understanding that, we're going to be quote unquote reopening on July 1st. There's still ripping the Band-Aid off. We still need some logistical procedures in place to start reopening. And from my understanding, those are still forthcoming. So just so that we can make sure we meet all of the logistical requirements for notice. And then of course, one of our members is going to be calling in anyway. So I'm supportive of, moving that decision of in-person down the line for future meetings down the line. And once we figure out what the landscape is for in-person meetings. So with that, legal counsel, do we need to motion as to the time and date, and as well as Zoom or whatever, if it's Zoom, or I know we've been having problems with Zoom.
I would just quickly, this is because the board's most recently adopted open meetings resolution sets the default time as 1 p.m. unless otherwise noted. So I would go ahead and just do a quick motion that our next meeting will be on July 23rd at 9 a.m. via an online platform and part open.
Great, thank you for that guidance. Members, is anybody ready for a motion? Yes, Member Honker.
I will move that we move the next meeting to 9 a.m. on July 23rd via an online platform determined by the department.
I'll second that.
Great. Okay, if there's no other discussion, Ms. Jones, would you be so kind to do a roll call vote on that?
Certainly. Member Bitzer, how do you vote?
Yes.
Member Cates, how do you vote?
Yes.
Member Duval?
Sorry, I'm looking at I'm trying to clarify my calendar here. What was the exact time again?
It's 9 a.m. on July 23rd.
Yeah, I vote yes. I vote yes.
Okay, thank you. Member Garcia,
Yes.
Member Honker,
Yes.
Member Trujillo Davis,
Yes.
Chair Sweeney.
Yes.
Chair Sweeney, the motion passes.
Thank you, Ms. Jones. Appreciate it. All right. Well, with that, it looks like we're at the end of our agenda. Is there anything else, Ms. Jones or legal counsel, that we need to, okay, consider or discuss? Okay, great. Any members? There's no other discussion items. I'd be happy to entertain a motion to adjourn.
I move we adjourn.
Thank you, Member Hunker, and
Second.
Member Garcia seconds. With that, if there's no other discussions, Ms. Jones, would you be so kind to do a roll call vote?
Sure, of course. To adjourn, Member Bitzer, how do you vote?
Yes.
Member Cates? Member Duval?
Yes.
Member Garcia?
Yes.
Member Honker?
Yes.
Member Trujillo Davis?
Yes.
And Chair Sweeney?
Yes.
Chair Sweeney, the motion passed.
Great. Thank you so much, Ms. Jones and everybody for your time today. And to our 2 hearing officers today, thank you so much for taking on that responsibility. Appreciate it. And everybody have a wonderful weekend, and we'll see you all in a month.
See you all. Bye.
Thank you.
Hope we all get rain.
Yes.
Exactly. Let it rain. Let it rain.